Good morning, all. This return date hearing is in the matter of DEC 001-2025 and is being held by way of video conferencing before His Excellency Justice Michael Black, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Al Tamimi Company. Lead counsel is Mr. David Holloway. The first defendant is represented by Quinn Emanuel. Lead counsel is Mr. Tom Montague Smith, KC. Thank you, Your Honour.
Thank you very much. Can we just do some housekeeping first of all? Have you discussed timing or
We did.
Sorry, do go ahead.
We did discuss it last week, Your Excellency, and I think we communicated with the court what we had provisionally agreed, subject to what Your Excellency would think of that, is that we take a day each, with me going first, and then we have a day in reply, again with me going first, and with Mr. Montague Smith having the last go. If that's still agreeable to Mr. Montague Smith, that would certainly be my preference.
Yes, subject to this, I suspect I'll be a little bit longer with my main submissions and a little bit shorter with my reply submissions. But we each agreed to equal time. What we haven't talked about is breaks. And so I'd assume that Your Honour would like to take an hour lunch and adjournment generally in the middle, but we're in your hands. And I suppose one might take 10 minutes in each session if needs be. But again, we're very much in your hands.
No, I think that's sensible if we take a mid-morning, mid-afternoon break. And yes, as you probably gathered from my request for the parties to consider appearing in person, I'm in Dubai, and of course all the court staff are here as well. So you'll have to forgive me sitting a normal Dubai day with normal Dubai breaks. So yes, we will take a short adjournment at lunchtime in the normal way. The only timing impact that I was going to have is that I'd rather determined in my own mind not to interrupt the two of you too much in your submissions, but rather to leave my questions for the end. I have some that you may or may not address during your submissions. If you don't address them, you'll get them at the end. There may be some more. So I'm going to give you both a fairly clear run rather than interrupt you. So I hope that's helpful.
Thank you.
In fact,
sorry, I was just going to say, if those are Your Honour's housekeeping issues, there is one other housekeeping issue that I would raise with your permission, if I may.
Yes, of course.
Rather regrettably, the claimant's team have taken to just inserting additional materials into the bundle. And they've done so without notice to us and just told us after the event. And they've done so without seeking permission from the court. Now, we had rather understood from Your Honour's comments at the last hearing that there was to be a guillotine on fresh material. And unfortunately, what has happened is that, you may have seen this, but my learned friend has not only put in supplements to the main bundle, but referred to them in his skeleton argument, and only after serving his skeleton argument delivered those materials to us. So that's the first thing. And the second thing is then he has, in his skeleton argument, given evidence about what Kroll does or does not say about things, and we've got some submissions to make about that. But we can deal with that as submission. But the third thing is that last night he has added in another 171 pages to the bundle. Some of it is factual material, some of it is authority, but he's not given us any indication of what passages he wants to refer to, or indeed what principles he wishes to derive from it, as I'd always understood would be the courtesy that was due to your opponent. Rather, they've just after the event given us this documentation. They then released to us the link to the bundle, which didn't work. And so we didn't have access to the material. I received it at about 3:30 p.m. UK time, 6:30 p.m. Dubai time last night. It's all a bit unfortunate. There's two things really that arise. The biggest concern is the factual material. We can live with the stuff that came in with the skeleton, but the factual material, there's 2 points. One is the ability to respond to it. But the other point is really one of equality of arms, because we'd rather understood that Your Honour was drawing a drop dead line under what could be introduced, and so we have acted accordingly. And so there are other bits and pieces that we would like to put in that we haven't put in, or we would have had FTI continue with their preparations. Now, it may be that Your Honour just doesn't want, just wants to reserve your position on all of this and hear what happens. And I can quite understand that, rather than making a ruling now that things are in or things are out. But I just wanted to lay that down now, because it's not, we say it's symptomatic of the way this case is being run.
Yes, I did want a guillotine for a very simple reason, that I download a bundle at a particular time, and that's what I do my preparation on. If there's material that isn't in the version of the bundle that I have downloaded, I have not seen it. And if I've not seen it, I've not prepared, and that's unfair. So what is the position, Mr. Holloway?
Okay, well, Your Excellency, there were two documents put in the original bundle that were referred to in my skeleton. Two documents. One of them was the TrueCoin Techteryx standard terms and conditions, which my learned friend had referred to in his skeleton and criticised us for not adducing in evidence. That had been originally adduced by Mr. Britton in his Hong Kong evidence, so we didn't see any harm in putting that in. It's been referred to, it's been discussed before. There was only one other email sent by Mr. Britton, which we put in the bundle, which was not formally exhibited. I believe that was also originally in the Hong Kong proceedings, and that was just simply confirming that he knew that he'd been speaking to the investors on that point of knowledge. Those were two documents. Sorry,
my learned friend's making submission. No. My learned friend's making submissions on the content of the documents, and that's unacceptable.
Okay, let's take it a step at a time. Okay, just tell me what the documents are, Mr. Holloway.
So those are two documents that were put in the bundle and referred to in my skeleton that were not formally adduced in evidence in these proceedings, but were in the Hong Kong proceedings and were referred to by Mr. Britton or came from him. Two documents: one, the Techteryx standard terms and conditions with the coin holders, and two, an email from Mr. Britton. That's all.
Which will be the subject of submissions in due course. Right.
Two documents, yeah. Last night we put in 4 authorities. Sorry, I beg your pardon, 5 new authorities and 1 document that had not previously been adduced. That was simply a letter from Kroll confirming that they had complied with their duties as an expert in response from the attack that was made on them by my learned friend and so on. That's it.
Okay, we'll come.
It's not it. There's also bank statements, and there's also a DMCC list of approved activities. So my learned friend's description of his own additions is inaccurate.
Those are authorities. The DMCC rules about what you can and cannot do pursuant to certain licenses. That's law. So we've exhibited some law on that last night. I'm not going to refer to it extensively. It's a very simple point.
Well, we'll cross that bridge when we come to it. Okay.
And the bank statements were the bank statements that were sent to us by Mr. Britton that were not adduced by their experts or our experts, but we found some things in there that we wanted to highlight, 3 or 4 things. But they're Mr. Britton's documents. They're not anything that could take him by surprise. It's just further analysis of those bank statements. We weren't allowed to put in any further crawl analysis, but some things were spotted in the bank statements, and we wanted to put those in. Now I could either have tried to file another exhibited witness statement exhibiting those statements, but I just don't think the content of those bank statements can in any way be controversial.
Well, I think as Mr. Montague-Smith anticipated, I'm not going to rule anything in or out at this particular moment. We'll see how we get on. I think it is very unfortunate to have late documents, not least because it inconveniences me and disturbs my preparation. And in a case like this, preparation is everything. I don't know where these documents are. You're going to have to help me find them. I certainly was unaware of them when I looked on the court file. They're certainly not in the downloaded documents I have. So we're going to have a bit of a struggle when it comes to it. But there it is. And we can also look at the admissibility and fairness of them if and when they're referred to.
Thank you.
So I take that on board. Mr. Montague-Smith, anything else?
Nothing from me, thank you.
Okay. Mr. Holloway, anything before you start?
No, thank you very much. Apologies.
Okay, well let's get a move on then. So it's down to you all today, Mr. Holloway and Mr. Montague-Smith, all tomorrow.
Very grateful. So, Your Honour, Your Excellency, as you know, this is round 3. Return date 3 of these proceedings, so I'm not going to introduce the background and the facts and so on. I think we're well aware of the basics. What I propose to do today is probably to divide the submissions into 2 parts. The first will be on the facts and the evidence. I'll probably take the whole morning on that. And then the second part will be on the law and full and frank disclosure, which I'll get to in the afternoon. So that's my structure. And in terms of the analysis of the facts and the evidence, I'm going to break it down into 3 parts as well. The first part will be about the use of the money, following the money, where the DMCC investment went. The second part will be about the assets and the asset disclosure and whether there are any assets. And the third part will be on various smaller topics that have been raised by Your Honour. So that's really the roadmap for me. I'll start then with the money and try our attempts to follow the money. And I think I'll just get stuck straight in to Mr. Britton's evidence on this first. And I think the conclusion of all of this will be that the factual narrative leaves no room for doubt that we do have a serious issue to be tried on our claims in Hong Kong. So I'll start with what Mr. Britton said in his first affidavit in Hong Kong, going all the way back to what he said in the Hong Kong proceedings. And if I can turn that up, it's in his first affidavit in Hong Kong, and the page number is 1699, 1699. Paragraph 32 in particular. So what he said there was that in return for the DMCC payments, what we got was Class C 3-year 6% coupon shares in the fund. And he exhibited to that statement documentation reflecting the Class C subscriptions in the fund that he said that he got with that money, and only those documents. So there was no reference to any other subscriptions, any Class B or Class D subscriptions. There's no reference or explanation of any porting exercise that took place. That was his first explanation back in Hong Kong. And then I'm going to sort of move to what he's been telling this court and move to his first affidavit. Sorry, Your Honour.
Sorry, yeah, just give me the date. Would you give me the dates as well? I said I wouldn't interrupt and ask questions, but it's helpful to have the dates of these things.
The date of that Hong Kong affidavit, I'm going to have to go to the end, I think, but that would have been back in the several years ago. It's the 3rd of June 2024, and you find that at the end. It's at page 1718. So that's explanation number one. You invested in the fund and you got shares in the fund. Explanation two was what you heard at the first return date in these proceedings. So that would have been in March 2025. And we're looking at Mr. Britton's first affidavit here, page 1816. And the explanation starts at paragraph 25 of that affidavit. So looking at paragraphs 25, 26, and 27, the explanation given at that point was not that the funds initially were in exchange for Class C shares in the fund, but rather it was a loan. And the FDT provided the DMCC payments to DMCC by way of a loan, and then Aria DMCC on-lent the money to different trading entities in the Aria group. Then he says, for the first time here, no shares were recorded in the share register, but the position was later regularized. So it was a loan, apparently, rather than a subscription at that point. And then just to follow on that, the trade finance facility that he referred to in that affidavit has never been seen. It wasn't produced in the exhibits to that affidavit. What we got was an unsigned document, undated, that didn't have the parties on it. And Your Honour, you remarked on that as an anomaly at the time in your first reasons after the return date number one. So that explanation is not the same as he gave in Hong Kong. It wasn't backed up, hasn't been backed up by any documents. And Kroll, I mean, I guess we don't need Kroll to tell us, but they point out that they've never seen the trade finance facility and that the document that was exhibited, well, I think we remarked on it ourselves. It was unsigned, it was undated, it didn't have the parties on it, it didn't have a reference to FDT, it didn't have a value, and so on. Kroll, if you want the reference to what they say, it's at paragraphs 11.15, 11.16 to Kroll's first report. But that's simply stating the obvious. There was no exhibit that had the trade finance facility there, and it's never been produced. I think that explanation of the payments has actually been abandoned, and I'll come on to that. Just on another point, from the same affidavit, if we rewind to paragraph 23, Mr. Britton said at that point that the only reason that the payments had gone to the DMCC company was because FDT had raised an issue in relation to the payment of commissions to Glassdoor, which they call a related entity of FDT. That's what Mr. Britton says. And Mr. Britton says here that FDT were complaining that Glassdoor's commission was taking too long to pay. So they asked for the funds to be paid to the DMCC company instead, which apparently would speed up the process of that commission payment. Now, Mr. Britton's never been able to substantiate that claim that the DMCC payments, that the payment was routed to the DMCC company, his wife's company, because FDT had told him to do that. And he was asked, his clarification came later, and he says in his third affidavit, I'll just give you the reference to that, but we don't need to turn to it, 4063, he said that he can't find any record of that request. It must have been made orally. And just, I can tell you, because I know, and my learned friend knows, and Quinn Emanuel know, that FDT, in their evidence in Hong Kong, have said that that is completely not true. So, Mr. Chalk.
You said this in your skeleton.
Yes.
But I can't track it down in the record.
It's not in the record, my lord, because that witness statement was, I think, filed in Hong Kong about a week and a half ago or 2 weeks ago. It's been served on my client's lawyers in Hong Kong. It's been served on the first respondents' lawyers in Hong Kong. It's been served on Quinn Emanuel. We could have put that in, but we would have faced the complaints. And we can show that to you if you want. It's a short affidavit we can file.
I thought it was quite important, and which is why I looked for it, and why I'm concerned it's not before me. Look, I'm not going to waste time, because I'm not going to interrupt. Discuss this with Mr. Montague Smith, and see where you get to.
Okay.
I would like to see it, but ...
Yeah. Okay. So I'll stick then with the first affidavit, because this is where Mr. Britton first raised this idea of porting having taken place. And you'll see that paragraphs 31 and 32 of that same affidavit, page 1817, I believe. So he says there, again, FDT said that they noticed in December 2022 that they didn't have any shares in the fund, and FDT requested the administrator to regularise the position by porting the DMCC payments into the fund. And he says this would have involved the administrator amending its register, etc. And he says that a suite of documents was executed mirroring the documentation, etc., etc. Now, we've not seen that suite of documentation. We've seen some new subscription forms that he says were backdated later to reflect the thing. We'll get there. But the porting exercise, he says, at paragraph 35, that the consequence of this is that Aria DMCC handed its assets to the fund. So what he's saying there is that at the time of the porting, the end of 22 or early 23, new share documents were created to backdatedly reflect that the Class C subscriptions had always been in place, and as a consequence of that, Aria DMCC transferred its assets to the fund. Now that is just simply not consistent with the evidence of the asset picture, and there are lots of problems with that story, which we'll get to a little bit later, but the documents just don't simply back that up at all. The asset picture doesn't back it up, and the corporate documentation doesn't stack up, or we haven't seen it. So that explanation is not only inconsistent with the first explanation that he gave in Hong Kong, but it's also inconsistent with the other aspects of his evidence. And there are also concerns about whether that process could ever have been done lawfully in the way that Mr. Britton says that it was done. And here I'll refer you to the evidence that Ogier have given about corporate law. If we could just look at that briefly, there's just one passage of that evidence that I'd like Your Excellency to read. It's at page 5268.
You're going to have to bear with me slightly because a number of documents corrupted when I downloaded them, and mainly the Kroll report and the Ogier report. So I've got to go online to.
Sorry, Your Honour.
Just while I'm criticising documents, one thing that I did find quite annoying is that many of the documents are not OCR. Which makes it very difficult for me to comment on them in Adobe. In future, if both firms could ensure that the documents loaded to bundles are fully searchable, that enables me to highlight the comment. Okay, paragraph yes, what of Ogier?
Paragraph 3.15. That's a page. Well, sorry, you're looking
yes,
at your
5270.
Yes. So we've not seen a paragraph A there. There's no share resolutions confirming that this exercise, reclassifying shares, happened. Then I think more importantly, paragraph C there, going over the page. So the second sentence, the commensurate amount of shares would need to be issued as consideration is being paid to the fund, not simply at a different time. Shares should not have been issued at a discount or premium or to the detriment of other shareholders to recreate the position that it would have been in had the DMCC payments been made to the fund, particularly if the DMCC payments were not treated as commingled with the fund's legal portfolio over the approximate 18-month period. So it's not clear on the face of the register without seeing the account what exactly has happened. That point's not been met, but it's as well as a legal point, it's a sort of common sense point here. If you get an investment into the fund in 2021 and 2022 is not the same as an investment in the fund in 2023, and recalculating the share values of everyone in the fund doesn't seem to be something that you can do without reference to the overall authorised share capital and so on and so forth. So the story is that all of the shares were revalued at that point. So instead of having a price of 1,000, I believe they were revalued to a price of 10. Is that so? That just simply hasn't happened and probably couldn't happen lawfully unless it connected with capital moving over at the same time and the other shareholders had not been prejudiced by that. And we just don't see any evidence that it's happened properly. Then I think to move to the next explanation that Mr. Britton gives, which is in his third affidavit, and this has some more detail about the backdating of the subscription forms and so on. Now, this really has only happened when the problems that we just talked about with the first two versions of the story have been pointed out. But the third explanation is a different one from the first and the second ones. You'll see the explanation, and now we'll look at his third affidavit. It's at paragraph 39, and that's 4041. And in that paragraph 39, he talks about original subscription forms 39A, and then he says for the investment in Aria Dmcc, and then confirmation of subscriptions for the investment issued by Aria Dmcc, and then paragraph D, confirmation of the subscription issued by the fund after the investment in Aria Dmcc had been ported into the fund. What this seems to be saying is that the original payments to DMCC were not a loan, as he first said, but they were somehow an investment in the DMCC company, which, and then later that was swapped for an investment in the fund, and the fund confirmed it. That's a completely different version of events from the first two. But also, as we, I think, explored in the first return date hearing, that carried with it an admission that the documentation that had been produced and exhibited in Hong Kong was not correct. Those Class C subscription forms that Mr. Britton exhibited and told the Hong Kong court this is the story, he now says they weren't 2021 documents. That's what they say on their face. These are backdated. They don't have the date on which they are created. They say they were created on a different date. So we say that is, and we said that that's strong evidence in support of our claim that this is a fraud. Then there's no real support for this later explanation from anyone else, Your Excellency. So what the first respondent has done is put evidence in from Mr. Van Buren, who is a non-executive director of the fund, working for a company management company that provides these kind of services. His evidence doesn't say anything about this process or what really happened. And it actually involves an even different explanation. So I'll just turn you to one snippet of that, which is paragraph 19. That's at page 6398. And I'm looking at paragraph 19A here. Here he says, sorry, Your Excellency, do you have it? So he says here that the original investments were made into the fund by legacy, to Aria Commodities Dmcc for what he calls the functional equivalent of ACFF subscriptions, and then says that the subscribers asked for them to be recorded as subscriptions in the fund. We don't know what that's supposed to mean. Your Honour, what is the functional equivalent of a subscription in the fund? It is not the subscription in the fund. It is not a loan, and it is not an investment in Aria DMCC subscriptions. So that appears inconsistent with any of the versions that Mr. Britton's given us. Certainly doesn't corroborate any of them. And it's quite striking that Mr. Van Vuren does not explain the porting process, if that's supposed to be what happened and how it happened. And there's no real evidence of that at all from anyone apart from the vague evidence that Mr. Britton's given. There's nothing substantial at all. And it's never been mentioned in Hong Kong. It's never been mentioned in meetings between the parties. It's been mentioned here in this court for the first time. Can I then turn to FTI's evidence on this? This is the first respondent's evidence. And they deal with that in their report at paragraph 8.8 at page 8928. So here they say that their understanding is that the DMCC payments were loans to Aria DMCC. That's their understanding of it. And that seems to be failing to catch up with what Mr. Britton's story. So they're corroborating the first version of events, but not the latest one. So, that's the shifting picture of this, and it's wholly unsatisfactory, and the backdated documents and so on just don't make any sense. Can I move on to then what happened to the monies? And remember, what we've been trying to get at for the last nearly 3 years is where the monies have gone, and who's benefited from them, who's the ultimate beneficiary of where they went. That's what Your Excellency's order said, but we just can't get to that. And I think the first point is even FTI, the first respondent's expert, can't explain what's happened to these monies. I don't need to delve too deeply into that because they've set it out quite neatly in a table on page 8885. Page 12 of their report, if that's what you're looking at. I think the problem with this table is that there are nearly $400 million of payments where FTI say they can find out where it first went to, but they don't know why. They don't know the purpose of that. So that's 386 million is the sort of headline number on that table. So that's a table that I'd like to just look at a bit more carefully, because if we're looking at this bit where they found out where the money initially went, but they don't know why, there are three rows that stand out here. We've got payment to other Aria entities. That's $228 million. We've got payment to other accounts of Aria Dmcc, and that's $76 million, nearly 77 million. And then payments to the fund, which is $21 million. So we know.
Sorry, can we just travel
Yes.
down? Can we take me to those again?
Yes. So if we look, the figures lead to a kind of conclusion at the end. And if we look at the conclusion near the bottom, payments for which I have only identified the beneficiary.
Yes.
386 million is the total. And I'm just highlighting that that's made up of 228 million, which is called payments to other Aria entities. I've got 21 million payments to the fund, and then 76
Sorry,
million.
where's the 20? Where's the 21 million?
Just above the two.
Got it.
Yes.
Okay, and then you've got the 76 above that. Yes, I've got that.
Yes. So the analysis stops really when the money first leaves the 4 DMCC bank accounts, and they tell us general terms. We know that this has gone to Aria type or named entities, but we don't know why. And then we've got, of course, just some points about that. That's the whole point here, Your Excellency. We don't know where those monies went. We don't know what was bought with them, if anything, and we don't know where it went after that. So they have given us, the first hit of where it left the bank accounts and nothing more than that. And then, secondly, for example, $76 million has gone to other Aria DMCC accounts, but we don't know. Well, we know it's not there now, but we don't know where it went after that. And indeed, these are not just the 4 bank accounts. Aria DMCC has many more bank accounts, and FTI only analysed the 4 or 3 of them actually, as to what happened with the money. So it's those huge gaps that tell you that we're still, probably one step further forward following Your Excellency's order, but not much further than that. They've also, FTI, what they've done is that they've looked at 3 of the bank accounts, and they've said that what they've done is they've analysed how the monies have left those bank accounts until it reaches the value of 1 million, and then they've stopped looking because they've reached the conclusion that, well, the bank account must have been emptied at that point, so there's no point looking any further. And they say that at para 6.5 of their report. I'll just give you that reference. I don't want to flick too much back and forward, but we say there's a big flaw in that analysis, because you can see that this money is circulating around the Aria DMCC accounts and around Aria accounts, and they need to be pretty clear that once those accounts reached the $1 million level, they weren't replenished by other payments from Aria DMCC or other entities. So that, we say, is a flaw in the analysis, apart from the fact that we just don't know where it went after the first transfer. They've also said that 25 million they just can't explain on that table. And, you know, we've seen some of the payments that they've identified going back to the table on 8885. I think we see, for example, $30 million, one of the fourth row down, payments for hedging, $21 million, again, for hedging. We really have no idea what those payments are. We don't know what was the purpose of them. It could have been anything. Next point I'd like to make is that FTI's analysis here.
So do we know who IG is?
One of them is a DMCC company. Sorry, a DIFC company.
Payments to IG Limited, 30 million. Do we know who IG is?
It's an online trading company.
Okay.
That's what we know about that.
And North Dimension.
Well, I mean, what I've been instructed is that this is a company that has links to FTX, and I'm not sure whether that means it's a crypto trading company or not. But,
okay.
But part of the pattern here is that's, as far as we can see, money going into a black hole, because we can't see any assets that spring from that investment at all. Now, next point I wanted to make is that FTI, their analysis is inconsistent with Mr. Britton's evidence about where the money went. And I'll start again with his first affidavit. And that's it. I'm looking at paragraph 29 and paragraph 30 at page 1817. Now, here he says there were loans of $100 million to Aria Bio, and then a trade finance facility payment of 200 million deployed in the sum of 150 million to Aria Australia, the loan being routed via a loan from Aria DMCC to a United States entity in the Aria group and advanced to the Aria Australia by way of a separate loan. So that was what he first said about how the monies had been used. And that changed slightly in his second affidavit. And his second affidavit is at page 2568. And I'm looking here at paragraph 25. That's the page reference for that paragraph. Talks about the trade finance facilities, 175 million, not 250 million, and only 100 million was drawn down he says. And then at paragraph C, the loans to Aria Bio were 80 million. Yes, lower than the figure of 100 million that he first said. And then he refers to another finance facility to a Ukrainian entity, an unknown Ukrainian entity. This is paragraph D. A standalone. And then he says that that Aria company is owned by a third party, not part of the DMCC group or the Aria Cayman group. So that's a separate, loan to that entity. But FTI don't spot any of that in their analysis. They don't refer at all to an Aria Australia receiving any money. According to FTI, Aria Bio received 30 million, not 80 million and not 100 million. Aria Ukraine, FTI say received 69 million.
You're going to give me some references.
Yes, I think I can. If I can. Yes, I'm looking for the Ukrainian one. 8911, first of all. This is the analysis of FTI looking at where the Mashrek accounts had gone, the Mashrek payments had gone. And you see, for example, the third row down, table 6.2, I'm looking at, sorry. Yes, sorry, it's not the third line down. It's payments for which I've identified the beneficiary and purpose. 1, 2, 3, 4, 5 rows down. That's a payment to Aria Ukraine of $69 million. And I think that's the only reference to Aria Ukraine. So that's much more than what Mr. Britton said. And then if we look at, for example, Aria Bio, we'll start again with the same table. And the same section, payments for which I've identified the beneficiary and purpose, payments to EGBS, GBG, Aria, FZE. That is 25 million there. Then if we look at their analysis.
Sorry, you're going too fast for me.
I do apologise.
So let's go to the Australian one.
Okay, yes.
But where do I see the Australian?
Well, there's nothing there.
But you said before FTI say there's 30 million.
No, that was
your submission. I took it down.
No, that was Aria Bio, Your Excellency, 30 million instead of 80 million. And I was just taking you through that. There's no reference to Aria Australia making any payments to Aria. 30
million to Aria Bio.
And I can track that through for you.
Yes, please.
So the first is
same page.
Same page, yes, and about sort of just below the halfway point of that section, there's a payment to EBS, GBG, Aria, FZE, 25,700,000. That's from the Mashrek accounts. So that's number one. Then the Adub account, that's at 8914. And just 1, 2, 3, 4, 5 column, 5 rows down, sorry, 2.6 million payment going from the Aria account.
Okay.
And that's it.
Okay.
And then we see there are lots of other Aria entities that get money, but we don't know anything about them. We've got Aria Real Estates, Aria. I don't want to get into the weeds on that, but only 21 million has paid to the fund. And that's just not consistent with Mr. Britton's evidence of those big payments. And even those two accounts that he gave are inconsistent with each other, although one could say that he corrected, he wished to correct his first one. But and then the last point I just wanted to make is that another part of FTI's analysis, another premise of it was that they only looked at payments that were over $1 million. And we again say that that raises some questions, because when you look at the smaller payments and add some of them up, they look to us to be suspicious. And this is where we adduced some bank statements to back that up, Your Excellency, and this is what Mr. Montague-Smith was complaining about. I don't necessarily need to take you to each one of those payments, but I will give you my submission as to the overall. There are 3 or 4 things that we say raise concerns about that premise. The first one is Mr. Britton himself has received about $4 million of payments from what we can see when you add up smaller transactions that are less than $1 million. The second point is that we see some very expensive school fees being paid from these accounts for people called Alexander Newman and Matthew Brock, transactions in the sums of $58,000, $56,000. We see travel expenses adding up to nearly $500,000. And then we see some personal payments, which seem questionable to us at first glance. $900,000 has been transferred to the account of Peter Williams, who Your Honour may recall is tied up in the Carbon Resilience Company, but these are payments to him personally. We have a loan of $68,000 to Mr. Gangel. We have $370,000 transferred to a lady named Amanda Murray, and nearly $200,000 to Mr. Oleg Levchenko. And this, what I'd say no more is that we can't just assume that the 1 million threshold is the magic number for helping us work out where this money has gone. I'll not get into the bank statement if it's going to cause a row, but we've just wanted to reassure you that I'm not just saying that, that those payments we've got from the bank statements that we've been given, and some of them we've been given very, very recently. So the conclusion that I wanted to draw from that, from the movements of the money, is that this just doesn't give us a picture that we're supposed to be getting from paragraph 14.2 of Your Excellency's order, we're supposed to know who the ultimate beneficiaries of the funds are and to have a full account of the onward dealings. We've had to drag the first respondent to court to give us their bank statements, which they had to do, they didn't want to do. And the bank statements themselves give us no more than the first wave of payments out. They don't know why the payments have been made. They don't know if anything of value has come of them, or what's happened to them after in the Aria web of companies. So we say the first respondent is still in non-compliance with your order, Your Excellency, and you pointed out at the last hearing that was so. So those are my submissions on the monies. The next topic, a related topic that I wanted to address, is the assets, because I think the point of Mr. Britton's asset disclosure was not just to tell us what DMCC's assets were, but to give an account of the onward dealings of the monies and who the ultimate beneficiaries were. I believe the approach that Mr. Britton has taken is that these assets may be the fruits of the monies, and that's why he's listed them. Your Honour, you'll recall at the first return date hearing, I made submissions that we just got that asset list, I think the day before the hearing in its final form, and my submission was that there were huge question marks about some of those assets, whether they really existed, whether the first respondent actually owned them, and that's been contested. But I stand by those submissions, and I'm going to go through some of the examples of this with you now, if that's okay. So you'll remember, Your Honour, there were two versions of the asset list. The first one was produced with Mr. Britton's second affidavit, but that was, to be fair, stated to be provisional and was working under constraints of time and so on. The second version was produced with the second affidavit, and it's exhibited at MWB 4. So that's the one I'm going to look at. I'm not turning to it yet, but we probably will be looking at it. It's at 3993. That asset list set out 513 assets divided into different categories, and obviously we're not going to be able to trawl through it, but I'll just explain what how Kroll approached this exercise, because what they did is they tried to narrow the analysis to some of the bigger assets that took up the sort of bulk of the value that Mr. Britton's asset list purportedly contained. So what Kroll did was identify 7 key assets, and they did a table of that at 4836. I'll just show you that if I can first. So this was
this is a corrupted page. So
I do
let me
pardon. Does Your Honour have would you like us to send a clean version of just any of these documents? We can.
No, because it won't be paginated. So I'll go to the online version of my book. Okay, I have it.
Yeah, I'm sorry, I'm flicking a bit between these documents, but
Doesn't matter.
the headline really is what they've done is the first 7 items on that table. They've said, well, look, this is the bulk of it because 90% of this asset list is tied up in those 7 assets. So let's just analyze these. And that's what they did. We're looking at Tanzanian mines, carbon resilience shares, the Indonesian coal plant, debts from Keirstone and Gloppet, Green Islands opportunities, loans, and the bitumen business. And before we delve into it, Kroll's looking at all of those as best they could, doing due diligence on records and looking at the documents that Mr. Britton had submitted, concluded page 4836. I can read this to you because it's short if the document is unwieldy for you, but they basically said we consider on the documents to date the majority of these alleged assets either do not exist or are not beneficially held by the Aria group, or they lack adequate documentation to support the purported valuations. So that's what we're delving into, perhaps in the next hour or so, if you can tolerate it that long. Next, I'm going to look at FTI and what they've done. And what they've done is at page 8880. Now, is this one corrupted, Your Excellency, or is this? Is it?
No, I have FDI on my PDF.
Right. So they've said I'll start with 1.13. They've not looked at every issue, and that's fair enough. But then flicking down to 2.23, they say, I've been instructed to direct the remainder of my review of the asset list to the 3 largest assets owned by Aria CFF, the Pinewood Resources Tanzanian project, the Mbuu Tanzanian mining project, and the carbon resilience shares. So the 7 key assets that were looked at by Kroll, only 3 of them have been looked at by FTI. And I would submit that even on those 3, FTI haven't really answered what Kroll have said, and it's not really what Kroll have said. It's basically common sense analysis of some of the documents that have been put forward here, particularly on the valuations. But FTI have challenged 3 out of the 7, and they haven't commented on the other 4. I'm just framing this for the moment, but the next point I wanted to make is that Mr. Britton himself has given various accounts of the assets that the fund have held, and that has changed over time as well. So I'll give you a few examples of that. First, there was a meeting between various people, Techteryx and Mr. Britton, in November 2022. And I know Mr. Britton is now saying that he didn't know that Techteryx were at that meeting, but he's not denying that the meeting took place. And as far as I know, he's not disputing the record of that meeting, which is being exhibited. You'll see the minutes of that meeting at page 5190, and this is November 2022. Probably could be described as the period where people were becoming aware that things were not as they should be. Now, what he says here on page 5190 at the bottom, or sorry, halfway, sorry, let me just go to the top again. The third bullet point, yes. He says here that Aria has a firm-wide AUM of 2 billion, 900 million in the fund, and Techteryx takes 65% of that. Then scrolling down a little bit further fund economics. Aria highlighted that the CFF.
Where are you looking?
Fund economics, Your Excellency, sorry, on the second page there, 5191.
Okay, yeah, I've got the next page.
Aria highlighted that the CFF is invested in two primary jurisdictions, Australian grain and Tanzanian coal. They make up 60% of the AUM. So he's saying there that that's about $500 million because he said that it was 900 million total. He says 187 to 200 million located in Australian clear grain system, 225 million in coal and the rest in assorted fuels. And then you see Techteryx starting to query why the fund, which is supposed to be an investment vehicle, the monies were actually invested directly in commodities and mines, etc. And then at the bottom, proof of assets, deviation from PPM. That seems to be Techteryx's concern at that point, that the investments are not in line with the fund's PPM. But they make some clear requests here. As a fund registered by the Cayman authorities, they should be able to find NAVs provided by the fund administrator. They asked for explanations of deviations from the PPM, and then they demanded the following. We're talking next steps at the bottom. They demanded the following: banking records from the top 3 banks through which the funds were deployed, fund administrators report. Aria agreed by December, although we didn't get the bank statements until not that long ago. Now that picture of the assets is not the same as what FTI or even Mr. Britton is saying now. And then going to look at another meeting between Techteryx and Mr. Britton in June 2023. I don't know if you actually had time to read that transcript.
Yeah, yes. Sorry, June 2023. I found it very, very difficult to follow.
Well, it's quite significant in many ways, and I'll probably be referring to it a little bit as we go on. But for now,
what's the page number?
It starts at 5009. But what I'd just like to look at in this context is some of the comments on page 5026 going on. And he talks about coal reserves at the bottom of that page, 26.12. He says there are 75 million tons.
Yeah.
Oh yeah, I do. Beg your pardon. Now, if you're following the sort of
5026.
5026, Your Excellency, and then if you look at the sort of timer on it,
Yeah.
it says 002612.
Yeah, it's got that.
So he's saying that the assets, they've got 75 million tons of assets of coal worth over 700 million, and so on. And
where's the 700 million?
Oh, sorry, that's yeah, right at the bottom of the page. The valuation is north of 700 plus million, which means the fund is at least 150% over collateralized. And then just skipping down to the next page, we have a comment from Bruno. Sorry, this is at 5028. And he says, where are we? There's a comment where he says, and then when we spoke about the coal last time.
Where are we?
5028. When we spoke about the coal last time, bear with me.
I'm glad I'm not the only one who found
Yes,
it.
and I've lost my reference here. Sorry, just turning over the page to 5029, I think. Going down now, please. Oh, yeah, sorry, go. Yeah, sorry, right at the end of 5028, 002947. Sorry, I've lost that reference, was not precise. He said, when we spoke about the coal last time, you said it was $1 billion, and now you're saying 700 million. When you bought the mine, what did you rely on for these figures, etc.? And then Mr. Britton says we acquired the rights. You just put a lot of infrastructure in place, etc. And then just flicking over to 5038. Sorry, the point there was simply the value of coal. At that point, it's supposed to be $1 billion or 700 million. And then at 5038, we're talking about when this coal mine was actually acquired. And looking at 003920, Mr. Dillerain appears here and he says, when did you buy the rights to this mine? And it talks about, was it 2019, 2018? And we don't get a clear answer there. But he's then asked on 540, what did you pay for the mine? No, 0040.
So where are you?
Now I'm on 5040, 0040.
5040.
Move further down.
And the reference is
4036. So he said, basically he invested a few $100,000 in the mine at that point. And sorry, just skipping back at 03933, if that's at page 5038, he says he bought the mines or the licenses in 2021, and he spent a couple of $100,000 on those licenses. That's what I believe is being said there. So he's boasting about the value of the coal, and they're asking him, do you actually own the mine? He said, I bought the licenses in 2021 for a couple of $100,000, And to be fair, at 5046, at 004534, they say, well, how much have you invested in the mine since then? And he says about 40 million. And then I think there's some discussion at the rest of that. The point being, Techteryx repeatedly saying to Mr. Britton, come on, if you've invested, two questions they're asking him, you're investing a couple of $100,000 in a mine, how does that turn into $1 billion? Number one, it just doesn't work on the maths. And number two, they're saying that wasn't our money that you spent. Where's the other 500 million? What did you do with that? And that's what comes out of the transcript. I know it's slightly difficult to read, Your Excellency, but it's actually a very instructive document. Because
you're going to have to point me to the bits you're relying on.
Okay, so we'll start with 5045. Just scroll down. So Bruno Adrat says, you're saying that the only assets backing up these notes are the mine and the grain.
Sorry, where are we?
And I'm going to have to 4441.
Yeah.
I can't see it. The fund only existed in 2021. You haven't got anything else, basically. Now, skipping to what Techteryx say, 5057. 5706. Thanks. Okay. So that is Techteryx saying, well, okay, so you bought some licenses for a few $100,000 and you've invested 40 million in a mine. Where's the other 500 million? So you're going to have to tell us the breakdown of what you spent our money on, and so on.
Where are we looking?
Just where I. The center of the page. Yeah. 005706.
5706. Yes, I've got that.
So where's the rest of the money, basically, if that's what you spent it on? Well, that's not much, so where did the rest of it go? The next 5072.
5072.
Yes.
Okay. Yep.
And again, as a Steve, and I'm sorry, I didn't put the lines down. Let me just. I've only got one more, Your Excellency. Just bear with me while I get the reference. Well, I'll. Oh, sorry, 5071. Just go back a page.
1 hour, 8 minutes, 40 seconds.
108.40.
07.
108.40.
Mm-hmm.
He says, what we are trying to do at this meeting is work out where our money's gone. And what you're telling us is you've got these grain assets, but that didn't come from our money. So
sorry, where's that? It didn't come from our money.
Well, he's saying
I'm sorry, you can't paraphrase this. This is a transcript. You just got to take me for the words.
Apologies. He says our context. If you scroll back, he says all of that's irrelevant in our context, the coal, etc., that they're talking about.
The
Our
worrying okay, on securitization.
context.
So I'm so sorry, I've now completely lost. What page are we on?
We're on page 5071 and
Thank
we're at line 010828.
Thank you. Thank you very much. Sorry to.
So our
That's
context is to figure out where our investment money is what he says.
Yeah, got that.
And then down to the next page, 10929. The next step, we want to see the full accounting to get into your system to figure out where, you know, as you mentioned, all the money went to here and they have substantial value somewhere. We want to have that access, okay? And I'll leave that there. And just one final reference. I'm sorry that's been difficult tracking that through, but
It's a horrible document.
it's, yes, artificial intelligence. There's 5056 at 5056.
We're going back, okay.
And then 005628 or 20, sorry. The point that I think I'll be making going forward, there's no magic that's going to turn a few 100,000 into 700 million right here.
Where are we looking? Sorry, where are we looking?
I do beg your pardon.
I've got
0056.
Oh, yes, 5620. Okay, got it.
So there's no magic that is going to turn a few 100,000 into 700 million right here on the, you know, discount to present value. So something is not right here. So that's the nub of it right there in 2023. We're being told that there are these massively valuable assets, but number one, we're querying whether these were the proceeds of our money, and number two, querying can we see the accounts to back up those valuations. And so I'm going to look now at some of those specific assets, the key assets that we were mentioning earlier, and that's the context. Your Excellency, hopefully it'll be slightly more plain sailing with.
Okay. You've managed to finesse it to 11:30, so you've got a 10-minute break.
Would that be a convenient?
That would be a convenient moment. Yeah, so we'll come back at 11:40. Divine time. Okay. Okay. Thank you.
Thank you, Your Excellency. So I'll just go through some of these assets one by one. And the first one is actually the biggest one, which is the PT Barra Energy Macmur coal. That is asset number 480 on the asset list. The first point to make is that Mr. Britton produced two asset lists in these proceedings, and the first asset list didn't mention this asset at all. So it sort of popped up in the second asset list, and it's slightly odd in my submission that it would have been forgotten about on the first asset list, given that it is the biggest asset that is on the list. Second point to make is that FTI haven't looked at it at all. Now I know that FTI say that they've looked at the three biggest assets belonging to the fund on the list. This asset is stated to be an asset belonging to Aria Dmcc. So strictly speaking, they have looked at the 3 biggest assets belonging to the fund, but they've not looked at this asset, which is the biggest asset on the list completely. And that's very odd, particularly given what Kroll have said about it. So first, this asset appears to be an option not yet exercised to develop some coal. And you see that from Mr. Britton's second affidavit, page 2581, paragraph 74. So he says, we have an option on this mine and it's valued at 247 million.
Let me just catch you up.
Yes.
2581. Aria 74. Okay.
Then I'm sorry, I'm going to try and turn you to what Kroll say about it.
Sorry, I can't find what you just read out a moment ago.
Oh, sorry. It's just that what the mine, they have development rights to the mine by virtue of an option not yet exercised, which had been valued at 247 million. That was all. Just really reading what Mr. Britton said.
Okay.
The point being, it's an option.
And that's valued 247 million.
And then just
we don't see valued by. Does the asset? Does MWB4 show the valuation?
We'll turn to that in a second. Yeah.
All right. You take your own course.
But just above that paragraph, the history of it, paragraph 73, A, B, and C. The right arose as follows. Emerson's Gulf were developing a mine with funding from Bank of Baroda. Emerson's Gulf did not have sufficient funds to complete the project. And then Bank of Baroda offered Aria Dmcc the opportunity to become the financier and investor for the project, for which 500,000 has been paid into escrow. So that's what that seems to be saying is that they've paid, I mean, I'll cut to the chase on this, but they've paid $500,000 for an option, and somehow that's been translated into an asset that is worth $247 million. Now, I'm going to take you through what Kroll have said about this. Because what they've done is do searches on that mine and that entity, and they can't find anything other than that Emerson's are listed as the shareholder in PT Barra. So there's no public record.
This isn't, by the way, a comment on your submissions, but it is literally true. You've lost focus. I can't. You've gone fuzzy. Is there any way in which?
I hope it's not a metaphor for my submissions, Your Honour. I will ask if someone can have a look at that I'm
It seems to
looking
be
at,
focused on the background rather than you. I mean, you are now the blur, and the background is.
oh, right, I'm the blur. I'm sorry, because I can see myself in the bottom corner and it seems on my side okay, but I'll get the IT people to have a look at this. Would you like me to
Yes.
wait or?
No, you carry on. I can listen to what you're saying. So you want to take me to Crom?
Yes, so it's page 5984.
Yeah.
And paragraph 16.3.1.3. So they've searched it and.
Sorry, now I'm getting slightly lost. 5984.
It's 4854. I do beg your pardon.
4854.
4854.
4854. Okay, now that's corrupted, so I've got to go to. I've got to go to 4854. Right, I have it. Paragraph
16.1.3
16.
and
Yep,
16.3.14.
16. So it's 16.3.1.
16.3.1.3 and 0.4.
Yeah, okay, not that.
So they can't find any record of Aria as a shareholder in that outfit at all. And so that's 16, sorry, I'm skipping down, 16.3.8, a couple of pages down. They can see reference to the 500,000.
16.3.7.
16.3.7, yes, they see a payment advice for 500,000. But that's the only evidence that they can find to show any ownership or any relation between Aria DMCC and that project. There's no evidence of title.
Was Mr. Britton claiming title?
Well, his evidence is as just.
Can I just go back? So
Yes, of course.
It is 2581, isn't it?
Yep.
2581. He doesn't claim title, he claims development right.
Yes, but there's no evidence of that. There's evidence of a payment, and he says he has rights, but we don't know what they are.
Yeah, but he wouldn't expect to find them in a shareholders register.
No. Well, if he was a shareholder in that.
And he may have development rights, but not be a shareholder.
Well,
or he may have options on share. But he said it's an option.
Yes, but there's no evidence of how it came about, and we know that we know how much it cost him, but that's it. So, for example, when you look at the Tanzanian mines, you do have shareholder resolutions authorizing issuing shares in those projects. You don't have it here. I think that's the point. And then in terms of valuation, all we have is a draft valuation report in support of that value of 247 million. That is exhibited by Mr. Britton, and it's at 3150. That's his exhibit for the valuation by Salva Mining Consultants. I think the first point is clear, the draft indentation in the report. The second point, if you look at 3157, even there, the executive summary, it says Aria Commodities Finance. Clear who that is, but they've engaged Salva Mining to prepare a mineral asset valuation for this project located in Indonesia, owned by Emson's Gulf DMCC. It's also states on that page that the report assumes that all financing permits are in place, which we don't know. Under mine plan, the second sentence, and it says the company plans to start production in 2024. Capital costs look like 30 odd million dollars on the other page, the next page. $33 million, I believe. Sorry, just going up 3159. There's a table. We look at the total cost is 33 million. It says 3227 has high capital costs because it's a remote location, etc. The concession is was issued in 2009. I'll take you to that, 3175. Yes, the table of data there at the bottom. Sorry. Yes, it's 2029. It's 20 years in length.
So where are you looking?
So there's a table of bullet points of data.
Page.
At page
3175. 175.
Yes.
Okay.
So Emson's got that license in 24th of August 2009.
Where do I see the date? I can see. Oh, there it is. Date signed, expiry 20.
And it expires with extensions possible. But that's it, really. I mean, there is a valuation of a permit, draft valuation. And really no hard evidence of what value Aria's interest in that would have, apart from that they invested $500,000 in it. Now, what Kroll have said, in order to make a proper valuation of something like that, what you would need to see is listed at 4856. I'm sorry, I'm turning it back to the Kroll report.
4856.
So that's, I'm looking at 16.3.11. Right, so there's a list of things. The main mining license, contract of works, mining authorization and other license and permits and so on. And remember, the draft valuation was subject to those permits being issued. It's a draft. That it's not a proper valuation of anything tangible, Your Excellency, and it's really another example of the idea that you can pay a few $100,000 for something and then say, well, I've got an asset that's worth hundreds of millions of dollars. It doesn't add up. And FTI have not said anything about that asset. So it's the flimsiest of evidence for an asset of that value. And it's also no real evidence that the monies, the DMCC payments, bought an asset of that significance, because only $500,000 was paid. And even that, I can just go back to the timing of it. Yes, the payment was made in 2024, January 2024. So that's after the alleged porting exercise. So it's and you can see that on well, Kroll noted on page 4855. So that's that asset. Your Excellency, just showing a payment of $500,000 and a draft valuation exercise with all those caveats on it can't come anywhere near to demonstrate that that asset is tangibly owned by Aria Dmcc or has a value of anything like that nature. But I'll move on now to the ones that that FTI have also looked at. So I'll move on to the Tanzanian coal mines next. Now there are two assets here. They are assets 451 and 452 on the list. They're both Tanzanian mining projects. One of them is named Pinewood in Bayer Coal, and that's allegedly worth 225 million. The other one is called Imbuya Mine Limited, and that's allegedly worth 65 million. So I'm going to take you through those. Your Honour, you've I'll start with Pinewood, actually, the bigger one of the two. And again, Your Honour, you're on it, mute. And
sorry, just remind me how you spelled the second one.
I've got it from the asset list.
EM.
Sorry, no, it's Imbuyu, MBUYU. Mine.
MBUYU. Yeah, okay.
Yes. I'll start with the Pinewood one, but in terms of both of these assets, the submission is going to be the same. The evidence of ownership isn't there, and the valuation or is tenuous, and the valuation is completely unrealistic. So let's look at Pinewood. So the title to these assets, which are mining licenses, the evidence that we've got in support of that are letters from Clyde & Co. In Tanzania. I'll take you to those first. So this is what FTI have relied on to value and verify this asset. The letters at 8810.
Sorry, give me the number again.
Right, so just scrolling down that letter.
No, give me the number, page number again, please.
Sorry, 8810.
Thank you.
So we're looking at 3 mining licenses there. What Clydes have said in their attachment to that letter, so going on to the second page, sorry, you can see, going up a bit more, at the bottom of the first page, second page, what Clydes have said basically is that these 3 licenses were acquired for $3,000 each. You'll find that over the page at the attachment to that letter on 338813. That's a slightly difficult document to read because on my version it doesn't rotate itself. But what that attachment says is that the licenses were acquired in 2025 in January for $3,000 each, and you see that at the table at the bottom.
Yes, got that.
So that's what the licenses were bought for. Then going back to the Clyde letter, it also records on the second page of the letter that the licenses had debts against them and paid charges and things on each one.
Sorry, where are we looking?
The second page of the Clyde's letter, 8811.
Yes.
And it says, moreover, it is worth flagging that based on the search report, there are outstanding debts in relation to the mining licenses as of April 25 as follows. So the rent penalties are there, and there's no explanation as to why that is. But the basic point is this: you cannot buy licenses for $9,000 and then say that you have an asset that is worth $225 million. It just doesn't add up at all. And also, this is long after the porting exercise, of course. So this is not where, this is not a valuable asset that was bought with the monies. This is an investment with a speculative value at best afterwards. It's also notable that if this is true, and if the licenses were only purchased in 2025, Mr. Britton was not truthful when he was talking about owning these reserves or licenses back in 2021 on the meeting with Techteryx and on the call that we trawled through. This is a very recent.
So where do we see the date of the purchase of the license?
It's on the attachment that we just looked at. 8813.
8813. Okay.
So these licenses were acquired in 2025. So if this is the
Where do I
transfer date, yes, January 2025, 25th, 23rd, I believe. And
yeah, I can see that. Yeah, very legible.
Yes. So that seems to be at odds with what was said earlier. Then on the other asset, the Imbuya mine asset.
Just bear with me. Okay.
Title to the second asset, the 65 million Imbuya mine one, the evidence that FTI rely on there is a letter from the Tanzanian Mining Commission, and you can see that on 8817, I believe. Yes.
So not 8817. It's 8816. Yes.
Yes. Sorry, the letter and then the license data is attached to that. What these are prospecting licenses, and it says that in the letter in 8816. If we look at the letter itself, these are the prospecting licenses, and there are 4 of them, and that's the table of them. Yeah, it also has a table of when they were acquired, and they're also acquired 2024, those ones. And then the letter, it says these are prospecting licenses. So what Kroll say about that is that a prospecting license is permission to explore. It's not necessarily giving you any rights over the minerals itself. These are not exploration licenses, they're prospecting licenses. So that's point number 1. And then just on the title, before we get to valuation, there are 2 shareholders' resolutions that are relied on here. So this is unlike the Indonesian one, that there are shareholding licenses giving transferring shares in these projects. So I just want to look at that because there are some anomalies in those resolutions, Your Excellency. So first, the Pinewood one, the 225 million one. This is a Kibo Energy Mozambique share resolution issuing Class B shares to the fund. So that's the source of the connection.
You've got a page for it?
Yes, of course. It's 5666. Look, a couple of points on this. These are ordinary non-voting redeemable 75% revenue linked participating shares, and the price is euro 0.01 per share. That's point number 1 that I want to raise because it's important in the context of the valuation. The second point from that first row of bullet points, it says they are redeemable at any time from year 5 onwards, but importantly, at the election of the issuer. So they are 5-year shares redeemable by Kibo Energy Mozambique Limited, and you get 225 million of those in column 2. That's the resolution. So what you've got there is 225 million Class B shares. Each one is valued at 0.01 euro per share, which comes to a total of 225,000. Yeah, it's 0.001. I misspoke. Sorry.
25,000 euros.
225,000 euros.
225,000 euro.
Yes. Now, that's what FTI use to conclude that there are rights to that Pinewood project. But then we have to look at the valuation, and the valuation is completely inconsistent with what I've just shown you. So I need to turn you to that now. Sorry, this first part is going to be a bit of a trudge, but
sorry, well, I'm afraid you flick backwards and forwards between Pinewood and Mabuyu. We're back on Pinewood now.
We're back on Pinewood because I just wanted to show you the first share resolution that was relied on as the evidence of title, and just to show you how that.
So you're going to valuation of which one then?
Pinewood, just to follow straight on from there.
Okay, would have been helpful if you hadn't interposed Mabuyu.
Sorry. So the valuation that FTI rely on for Pinewood is something they've exhibited along with their report recently. It's called DMCC 8, and that is at 8763.
876.
So this is Salva Mining Consultants again. All right. First point is the date of this report. It's at page 8674 and 5.
The date is September 2024.
Yes, 2nd of September. And it's a valuation of a preference share, it says. Sorry, just scrolling back up to the,
Yeah, I can see that.
So that's, first of all, it's a preference share, it says, and it's 2nd of September. But the share resolution that we've just looked at is dated 20th of September and is not a preference share. It is Class B shares, it says. Ordinary shares. So the valuation doesn't seem to be consistent with the share that they're valuing, or that FTI are relying on. It also has inconsistent valuations. It says it values at 225 million and 226 million. But really, the core of it is the way they valued this is at €1 per share. And you see that on
8768.
Yes, indeed. But we've seen that the share that we're talking about was issued at 0.001. So that's plainly wrong. It also, sorry, looking at that value again, it says on 8769 that they're valued at, it says they're redeemable at, sorry, I'm losing my maturity. The preference share is redeemable after 5 years at the election of the holder. But the shares were not redeemable at the election of the holder. They were redeemable at the election of the issuer. So that is a fantastical valuation that is just not based on reality or not based on the terms on which that share was issued. If you've got a share, if you pay €1.001 for exploration rights for 5 years, and you've got a share of the profits in that first 5 years, and then the issuer can redeem them, you certainly have no guarantee that you're going to share in whatever comes further down the line. But there's a huge difference between, well, there's a huge difference between €0.001 and €1. There's a huge difference between a share that's redeemable at the option of the issuer and of the holder. So if you're valuing on that basis, it's obviously not worth the paper it's written on, Your Excellency. Then I'm going to look at what FTI say about this. And they've been very careful about how they word this. They say it's a page 8920 and it's 719 to 21. They just conclude that there are rights to the concession and that they have been valued at 225 million. And that's consistent with the asset list. And then they say, well, I'm not an expert in valuing mines, so I can't comment on the methodology used to value it. Well, Your Excellency, I'm sorry, but you don't really have to be an expert in mines to spot those anomalies in that valuation. It's got nothing to do with mines, really. It's basic maths. And they've avoided commenting on that. Your Excellency, turning to the Imbu valuation, and the short submission is that exactly the same mistakes have been made. I can turn you first to the resolution and then the valuation if you wish, but it is exactly the same. There's a €0.001.
Let's just have a quick look.
Yes, so the resolution is 5664. Sorry, I may be one page. Maybe, oh, I've got that one. 5665. Excuse me. Ordinary shares.
Your yeah, okay.
And then exactly the same. The valuation. It is 01.
Sorry, say again.
The valuation is 8801, I believe. Sorry, it starts at 8789, but it suffers from the same defects.
Sorry, 878.
Same date issues.
So again, it's preference share, it says on the front, instead of ordinary shares. And then just one page further down, 2nd of September, and again, that predates the resolution, and the valuing bit um, 8792, I believe.
Yeah.
Yes. 65 million based on €1 per share issue price. And again, redeemable after 5 years at the election of the holder rather than the issuer. So it's the same issue. And again, FTI don't get into that at all. And they say, we're not an expert on mines, etc.
Reference.
8923.
No. No. 8923. Nothing. Inside the report, no. Wasn't available. Was not available. From not an expert. Yep.
Probably the same. And then just a final point on Imbeya Mine. I think Kroll had found public statements saying that this asset had been acquired for nil consideration, and FTI haven't commented on that. I can give you references for that as well if you like, but it's really the same point. There's no evidence that you can't put a couple of 100,000 and then say you've got a couple of 100 million. It just doesn't work that way. So this assets can't justify. The valuations are just completely not worth the paper they're written on. Similar pattern with carbon resilience, which would be the next asset I'm going to touch on. So this was a company that is valued at $143 million, and it's asset 452 on the asset list. This came up in the context of securitization because it was said that this carbon resilience project was connected to ownership of solar assets in Queensland. And Your Honour, you questioned the evidence on this before in the reasons, your second judgment, paragraph 77. You questioned the documentation and the connection of whether there was any evidence of assets in solar assets in Queensland and so on. I can give you the reference to that, but you've previously highlighted this asset as something anomalous. So I'm going to drill into it a little bit more.
Okay. You're doing this de novo now.
Yes, it's page 1177.
1177.
Yes, and it's paragraph 77 of your reasons. Second reason judgment you gave.
Yeah.
You said you can't see how the documents demonstrate the fund's ownership of wind and solar assets in Queensland, and really highlight some anomalies with the documents that were exhibited to prove that this asset was owned by the fund, including nominee arrangements. And you said towards the end of that, there's a nominee arrangement made between the fund and FAA or real estate, whereby the Liechtenstein company agreed to act as nominee for the fund in its ownership of carbon resilience by reason of regulatory considerations. But the nominee agreement states that the fund had effected the purchase of carbon resilience through the deed of transfer. That doesn't appear to be accurate. FAA or real estate received the shares and possibly may have done so on bare trust for the fund, but the nominee agreement seems to have been executed after that, and so it could not have done so as the fund's nominee with the agreement. So that basically was question marks about the fund's ownership of that asset. And what we've got since then are some share transfer forms which FTI have exhibited, which they say give you further comfort that the fund has some sort of ownership in this company. Now, those I can very quickly show you. Page 8847 onwards. And I just, before saying too much about it, it's an inspection copy. It's not, I'm not sure that is a finally executed. It's not dated. It's marked for inspection only. And if you look at the signature page at the end, the transferee hasn't signed it. And yeah, it's not signed by all parties. So that's just one point on that. But more importantly, even FTI admit now that the fund hasn't quite yet got any shares in this asset. And that's just at odds with Mr. Britton's evidence that
you have to give me the reference to it.
Sorry, I'll get there, Your Excellency, pardon me. It's at page 8887. Two parts. First one is at paragraph 2.24.
Okay, hold on.
Just the caveat in that paragraph. This is a general summary, and they say that the assets exist and that the fund has rights to them, and then brackets, or in the case of carbon resilience, will have rights subject to investment approval and so on. And then they deal with it again a bit later in their report. If I can flick on to 8924, paragraph 7.36. Sorry, yeah, it says the documents referred to above, meaning an agreement that we looked at, and the show, and I'll just skip to the conclusion, that the documents show that the shares will be held on behalf of Aria pending foreign investment approval. They don't deny Kroll's evidence, which is that the Aria are just not listed on the Singapore register as a shareholder in the company. And they also, quite importantly, say on the valuation of carbon resilience, page 8925, paragraph 7.39, they just can't comment on that valuation because they have no idea what carbon resilience's liabilities are. Now, bear with me. We still don't really have any evidence of carbon resilience's ownership of wind and solar assets in Queensland. And bear with me, Your Honour, I have one more point to make on that. Okay. We have no website in place for carbon resilience. The website is defunct. Kroll picked that up. These are smaller points. And then there is an investment proposal which FTI rely on. They say that the ownership is conditional upon foreign investment approval by the Australian authorities. And we see that at page 8851. And just scrolling, just looking at the part that's highlighted, foreign investment proposal fee details. All we see there is an applicant. Well, we see the applicant FA SPC Real Estate Income Limited, target carbon resilience, and so on. So that's really it. There's nothing in that proposal that mentions Aria or the fund and so on. So FT also, they rely on an EY valuation on April 2025. Again, that, well, I'll turn that up, 8824. All of this is a valuation conducted on behalf of a company called BIV IOS. It's not clear why they're valuing this, what the connection is with Aria, so that the documents relied on by FTI for this valuation are just, there's no evidence at all behind it. And Your Honour, you've raised the query before and it's not been answered at all. So in summary, there are 4 big ticket items of assets that we've just looked at. There's the Indonesian mine, the Tanzanian mines, and carbon resilience. And really, there's no clear evidence of Aria ownership or to support these very, very high valuations. That accounts for over 600 million, nearly $700 million of the asset lists. and FTI have not engaged on the Indonesian mine. They haven't really given any evidence on the Tanzanian mine and the glaring anomalies in there, and they themselves say that the carbon resilience shares aren't yet owned by Aria. So that's $700 million worth of assets that we still say aren't there in any real sense. There are many of the smaller assets that FTI have not considered. Keirstone and Gloppet, 42 million. Kroll have raised concerns about that, not answered. We have the Green Islands Opportunities, asset number 479, 16 million. Kroll have raised queries and questioned that, no reply. And just finally, loans. There are lots of loans that Kroll have said that there's no clear explanation of. The loans are assets 59 to 109, 440 to 4848. There's a whole, the total of those loans is a.
Sorry, what numbers? You just gave some numbers there.
Slow down, you're right, I'm sorry.
Yes.
The loans on the asset list are assets 59 to 109.
Yeah.
And 440 to 448.
Yeah.
The total of those loans is $107 million. And Kroll have just made a table of them at page 4862. Or some of them, some of the bigger ones. And you see Aria Ukraine, Aria Axe, an unexplained loan of 16.3 million and a loan to Aria Bio. These are inconsistent with Mr. Britton's evidence in relation to Aria Bio, Aria Ukraine, etc. But the conclusion Kroll have drawn on that is 4863, paragraph 19.5. The receivables, they just say they can't determine the financial position of the borrowers, the capacity to repay, the suitability of the value attributed to these assets. Nothing came back from FTI on that. So that's taken a bit of time, Your Excellency, but if I can just wrap that up, just to summarize, the asset number, the Indonesian coal, asset number 480, no convincing evidence, no evidence at all from FTI, serious queries from Kroll. The Tanzanian mines, the Pinewood project, serious queries from Kroll, lack of any serious analysis from FTI, the same with the Imbu mine project, the same with the Indonesian, the same with carbon resilience. And then in relation to some of the smaller assets, I'm just going to give you the numbers. Keirstone and Gloppet is asset 189 and 90, 42 million. Crawl conclude there's no evidence of an underlying asset there. No answer from FTI.
You have to take it slowly again.
Yeah,
Keirstone, Gloppet, asset.
That's asset 189 and 190.
That's it. 189 to 90. Yeah?
And what is said is that.
And how did you say 42 million?
42 million, yes.
Yeah.
So what is said is that those assets have been securitized and those two companies owe the fund 42 million. Crawl have said they can't see any evidence of underlying assets that have been securitized, and FTI have not addressed that concern. The next Green Islands opportunities. This was one of the key assets identified by Crawl. That's asset number 479. It's valued at 16 million. Crawl say they can't see any evidence or documents to back up that valuation, and FTI have not dealt with it. The loans I've just gone through with Your Excellency. I hope you have those references. And the only other one I'll comment on is the bitumen plant, which is I don't have the asset number for that, I'm afraid, because it's a combination of different assets. But what Crawl have said is they just can't see any documents in support of bitumen assets, no financial statements in relation to the Aria bitumen company or the asset that it holds. And they just can't determine what that's worth. And again, I'll give you the reference for what Crawl say about that, 4866. And again, that's something that FTI haven't come back on. So that takes me to the end of the asset position. I'm sorry that was a little bit of a trawl through the detail. But I have just a couple of smaller submissions on the fact pattern. It may take me more than 15 minutes, but it's not a long one. Shall I start?
Yes, of course. Yeah.
Start with the NAV statements. And this, I think the first respondent is relying on these statements to show that they have the asset pattern that they've just described is real. And these NAV statements were meant to be sort of periodic statements issued by the fund administrator. First of all, until very recently, we only ever had 3 of them. And Your Excellency, that's something that you marked as a concern in your first reasons after the first return date. And I'm going to turn you to that. It's page 1115, paragraph 26A. Now, one of the things that is being said throughout by the first respondent is that the fund cannot be a fraud because you've got these NAV statements that prove that it's genuine and it proves its asset position. But as you yourself have noticed, Your Excellency, they only had produced one at the time, or it went up to 2023 January, and there was no explanation why. Also, you noticed there's some anomaly between the intercompany receivables marked on that NAV statement. So it's been flagged from the outset. But right, when Kroll were analysing these documents, they only had 3 of these NAVs, one for July 2022, one for October 2022, and the last one from January 2023. And Kroll have had a look at those 3 because they didn't have access to any of the others. And their conclusion is at 4806. Paragraph 8.8. They say that the NAVs do not accurately reflect the financial position of the Aria Group and may well be fabricated because they appear to overstate assets and understate liabilities. And they go into some more detail later in their report, and I'll just dive into that a little bit now, if I may, before lunch. Looking at paragraph or section 9 of Kroll's report.
Sorry, just 1 second.
Yeah.
Okay, carry on.
Section of paragraph 9.1. The first thing they pointed out was that most of the assets on the NAVs weren't, if you like, tangible assets, but loans to other entities, which equated to off-balance sheet financing, and meant that they couldn't really be verified because you have a loan, but you have no idea of who the situation of the borrower, whether there's security, whether there are any assets backing it. So that's query number 1, and we're looking at the 3 NAVs that they had. The majority of the assets just seem to be intercompany loans, large part of the assets, I should say, and that makes it difficult to determine what the tangible assets behind that are. And really, that's what that goes back to what Techteryx were telling Mr. Britton in November 2022 and June 2023. You need you to open your books up so we can see where the money's gone and what's behind it. Second thing that they highlight at page 4009, paragraph 9.3.4. is the fact that each of the NAV statements have the same NAV per unit, if you like. It's 1,000 is all the way through. So NAV per unit is the net asset value of each share. And just to put it simply, as the asset picture fluctuates, the NAV per share ordinarily would fluctuate as well, because you're looking at the assets backing each unit. But what Kroll saw from the 3 NAVs is that the NAV per unit remained at 1,000 through all of the NAVs. So the subscription price, if you like, of 1,000 was used to generate the NAV statement. They weren't looking at assets and then valuing each unit. They were starting with what the unit price was, and then everything else fluctuates. So that shouldn't be the case. And they just give a little bit more detail on that in 9.3.5 to 9.3.7. They identified a small but significant, not de minimis mathematical error at 9.3.9, where adding up the liabilities, there was a mistake that was 1.3 billion out, and they felt that that was not something that would have been professionally done. So that was their analysis of the three NAVs that they had. The second, after that, FTI, when they were doing their analysis, were given a pack of new NAVs or extra NAVs that we never had. So what FTI were given were NAV statements starting from April 21 and ending in January 2025. And those have been put in the FTI report, but Kroll have not been able to see them before then. What Kroll have noted from the new ones is that on the metadata, well, two things. None of them are issued by the fund administrator. They're issued by Aria, number one. And secondly, the metadata gives the appearance that these documents were created in June 2025. Now, we haven't been able to explore that. That may be that they are copies of older documents, but there's a question mark about when these NAVs were produced, particularly since none of them have been produced previously, and that this dispute's been going on for some time. Now, looking at the new documents, FTI have had a look at them, and Kroll have looked at them as well. We see some further glaring anomalies here. First is that some of the largest assets, the ones that we've just looked at, don't appear on the NAVs at all. Or sorry, that's not correct. I misspoke there. Those assets, the Tanzanian mines, carbon resilience shares, were added into the NAVs in 2024. So that asset picture, they were added in quite recently, and some of them are not in the NAVs at all. And I'll go through those now. First is Bara coal, the Indonesian coal mine. That doesn't appear anywhere. That may be because they say it's a DMCC asset and not a fund asset. But in Bayer Power, which is asset number 439, valued at 25 million, doesn't appear in the NAVs. Two loans to carbon resilience, valued at 18 million, don't appear in the NAVs. And those are assets 444 and 445. Neither does.
Sorry. How much were they?
The carbon resilience loans there were two loans, one of 10 million and one at 8 million. They're on the asset list at 444 and 445,
Yeah.
but not recorded in the NAVs.
You better show me the NAV.
We have them in. Sorry. It's an exhibit to Kroll's. Let me just give me 1 minute.
Stop,
8592. Beg your pardon.
8592.
Yes. So I mean, apart those absences, obviously you won't find there. But the point I did make is that they're not issued by the fund administrator. There's a sort of.
You said that. Yeah.
And I had one final point on this, on the NAVs. They're not consistent with the porting explanation. Because the intercompany receivables with Aria DMCC are listed on these, and it varies a lot. So I can look at, for example, January 2022, 8598.
Where are you looking?
8598.
85.
Now we're looking for the intercompany receivables with Aria DMCC.
8598.
Receivables related parties. And then right at the bottom, the second from the bottom, you can see
Commodities.
so it's, I think the second, yes, Aria Commodities DMCC.
Yeah, 166.
166 million in January 2022. Then if you look at January 2023.
Sorry, January 22. January 23, yes.
8606. The same tab. Aria Commodities DMCC, third from the bottom, 119 million.
I'm sorry, could I have that again?
Sorry, it's at 8606.
It's about the middle of the page this time.
Middle of the page, fourth from the top, third from the bottom in the receivables column. So at that point, the receivables 119 million, and then going to 2024, 8614. It goes up to 309 million at that point.
The page number
8614.
8614. Yes, I'm so sorry.
No, I'm sorry. It's
yes, 309.
so just to, the point really is going back to the porting. Mr. Britton said that the consequence of the porting was that Aria DMCC's assets were transferred to the fund. If that were correct, and if that had happened, The intercompany receivables should be going down, but in fact they're going up, and it doesn't tally with the porting explanation.
Well, if they were treated initially as a loan, and then the assets were transferred, the loan would be repaid in specie.
Yeah.
Is that a convenient moment?
Yes.
Okay, we'll take an hour's break now in that case. Come back at 2 o'clock Dubai, which will be 11 o'clock London.
Thank you.
Thank you very much. Hi, good afternoon.
Yes. I had one small point I've been instructed to make on the Mburu mine. I've got one more document to show you on that, which is a director's report from Kibo Energy PLC recording their divestment of the shares to Aria. That is at page 6898. And I'd like you to look at the bit at the bottom of that page, disposal of investment in Kibo Mining Cyprus Limited. First sentence, yes, sorry. It's trying to find where it says, second line. Disposed of its interest in Kibo Mining Cyprus on 16th of November 2024 for nil. So that's a point. There was also an AIM announcement about that transfer, and that's at page 5144. It gives a little bit more detail on this. The fourth paragraph under disposal of Dmcc. I'm just invite you to read that paragraph, Your Excellency, but the again, it confirms that it was acquired by Aria for nil consideration and actually involved divestment from liabilities and debts and things. It says that Aria have assumed the historic payroll liabilities, netting off consideration and resulting from nil cash being received, and the group's indebtedness being reduced.
Forgive me, what is RTO?
I think it means reverse
Oh, I've got it.
takeover.
Reverse takeover. I found it. I found the definition higher up. Thank you.
So,
If you go background and reason of dispersal, there we go. 16 September. Company. 2 sheet. Arranged. Right. Okay. Dispose of the company holdings. Okay. Okay. All right. Thank you.
so just another point on the valuation. Now, Kroll has raised this in their report, and FDI don't address it at all. But a couple more shorter points on the facts, and I'm nearly finished with that. The first, well, the next topic I'm going to turn to is share registers, and we say that we still haven't got a proper register of the fund's shares, and Mr. Britton has come up with various versions at the various hearings, but we say we still haven't got the full register. Now, this is something Your Excellency raised, I think, at the first hearing, and I think right at the ex-parte hearing, I believe, one of the observations Your Excellency made was that the register that had been referred to in Hong Kong wasn't a register of subscription shares, it was the management shares. And you said it would have been easy for him to just put the full register in. I can give you the reference to that, but it was a short comment. And I think at one point in the hearing you said, I'm sorry to sound like a broken record, but if the share register could be put in, that would have been open for the first respondent to do. I can give you those references, but it's just background. So at the first return date hearing, what you got was he said it was an example of the register, and I'll point you to that. It's 1861. And if we can, so you'll see there were 4 pages there, dated from April 2021. And then the next page, sorry, I'm going to have to keep rotating as I go. I don't know if you can see it, but the next page is March 2022, and there's a list of investors at that point. And then I think that's the end of it. So he said those were examples of the share register, and that was supposed to prove that there was a share register, and so on. Then I'll just take you back to what Mr. Britton said at that point, because those were obviously not the registers that could tell us about our investments in the fund. And he didn't say they were, to be fair, he said they were examples. But then if I can just turn you back to his affidavit, it's page 1813. And he says, for example, at 11E there, that the administrator of the fund kept a register of shares, and that was updated periodically to reflect the identity of the shareholders and their holdings as they changed over time. Then he says these are the example copies. But then paragraph 12, he says, I've requested from the fund administrator complete copies of all the documentation referred to in paragraph 11, so including the share register and how it changed over time. And he said it hadn't been provided at the time, but he would provide it by way of further affidavit. Now, what we've never had is the complete share register as it changed over time, and as promised in paragraph 12 of that affidavit. At the hearing, the first return date hearing, another document was put in, and he said he had exhibited that share register. That was in his second witness statement. So there's a lot of these statements, but that's at 2376. So this is what you had at the first return date hearing. And my learned friend at that hearing said the share register issue has been solved. We now have the share register, and you see that that's a one-page document dated 14th of March 2025. It is headed by the fund administrator, and it shows First Digital and Legacy with these purported shares. But Your Honour, you made clear that wasn't the share register that would have been required, and that it was just an extract of the share register, and my learned friends accepted that, I think. So we left the first return date hearing with a question mark over that, and with the outstanding promise that the full story had been requested from the fund administrator and would be provided. So then we got another version of this in his, I believe, well, it's MWB6. I believe it's in his third affidavit. It's at 4750. And this is what we've got today, which is, can you flip down one page? It's a two-page document. It's pretty much similar to the one that you had in the first return date, but there's some redacted entries for other shareholders who allegedly don't have any shares anymore. But you'll see that it only is a list of Class C 6% shares, and we say that number one, that's obviously not the full story, and number two, we submit that this isn't compliant with Cayman law, and I'll take you to Ogier's evidence on that to make that point good if I can. I'll move to OGA and what they say, it's at 5273. Looking at paragraph 3.24 particularly, they say, first of all, that the registers don't provide an accurate and complete picture of the historical capital activity of the fund. I think that must be correct because it's a snapshot as of 2025. It isn't possible to determine, for example, whether the porting exercise happened from this register. And I referred to their concerns earlier about the porting exercise and the problems with the value of the shareholdings and revaluing and reissuing an authorised share capital. It doesn't deal with that. And they say we would have expected the fund to produce a register of members at any particular date, that members had certain shares to evidence the historical capital activity. They also say that they believe that this share register doesn't comply with the Companies Act in Cayman, and to the extent that there are additional classes of shares beyond Class C shares, they wouldn't comply with Section 40 because it's just a list of the Class C shares rather than a full register of members. They say the fund would have been expected to, or required to keep a record of historical capital activity, and under Section 59 of the Companies Act, and be able to show the shareholdings as they evolved over time. I think that those are their observations. They're also highlighting the question mark that Mr. Britton had said, that the fund administrator would provide a full suite of documentation reflecting how the shareholder register had evolved over time. And really, if he's expecting the court to believe that a porting exercise took place in January 2023, the register ought to reflect that. It doesn't. And I'll leave that there. Perhaps apart from saying that Mr. Van Buren Campbell's just haven't addressed that concern at all from OGA. So I'll leave the share register behind. It's a point that you'd raised yourself, Your Honour, earlier, and we say it's still there. I'll next move to audited accounts. Again, it's uncontroversial that the fund hasn't filed audited accounts for the relevant period in question here, 2022, 2023 and 2024, nor have they filed any or exchanged any evidence of financial records or accounting records or management accounts. We haven't seen any of that. I would remind Your Excellency that the financial picture of the fund is something that my client has been asking for since November 2022. It's evidenced in the record of the meeting that I took Your Excellency to this morning. And it's also repeated in the meeting in June 2023. The one that was transcribed. I won't. I'll risk just giving you the reference to that if rather than turning it up. But I do have the exact reference to that if Your Excellency wishes. It's at 5060 and 005930. where is the accounting for where the money has been spent, the 500?
Did you say 5930 or 13?
5930, sorry.
Thank you. Okay.
Where is the accounting for where the money was spent, the $500+ million? Where is the accounting done by a competent outside auditor that will certify where this money is spent? The securitization, this is a red herring. It's what we want to know, where the money went, etc. I'll leave it there. And we have, this is probably going to come up again in full and frank. We did have audited accounts for the year 2020 to 2021. And that obviously was a mistake in our first affidavit, that we didn't have any audited accounts. We did have the audited accounts for 2021, but we only got those in December 2023. And they were those same accounts for 2021 were not prepared until, well, the first version of them until the end of November 2023. And those were accounts made by Mazars in Dubai. They weren't the ones that were filed with the regulator. They were a version of audited accounts 2023 in November. And we then have, we know that a version of those accounts was filed, but not until late 2024. So there were two versions of the 2020-2021 accounts. One of them was prepared in Dubai at the end of 2023, and the final version, which was sent to the regulator, was prepared in mid to late 2024, and that's the only audited accounts we have for that year. That's not really the audited accounts that are going to help find out anything about where the money went. Now, I just want to make one point about this. The correspondence, sorry if I could put it this way, that there are two versions of these accounts. One of them prepared by Mazars in Dubai, and the other one prepared almost a year later by Forvis Mazars, who are the Cayman office of Mazars. And they're pretty much the same, apart from there's one difference. The ones in 2024 have added a section at the end, subsequent events, and they say that we've received since 2021 $500 million of new subscriptions. And I can probably should turn that up for you, Your Excellency, if I can. That's at 2474. So these are the accounts that were sent to the regulator in Cayman in August 2024, 3 years after the dates for which they're auditing. Now, if I can just take you to the end, subsequent events is what I want to show you, and I'm going to have to 2500, I'm helpfully told. So there was a previous, at the very bottom of that page, yes. Now there was a previous version of audited accounts that we received in 2023 that didn't have this in it. Paragraph 23, subsequent events. And then here it says, well, since 2021, the fund has received additional subscriptions totaling 512 million, and that's there. Now that sort of popped into the accounts between 2023, 2024. And I think what is going to be said is that this is somehow evidence that Forvis Mazars have blessed the porting exercise because they have signed off on these accounts with this note in it saying that there have been new subscriptions. And I got to tell you that there's no evidence of that at all. What we have is firstly a finally audited version in 2023, which made no mention of this whatsoever. So as far as November 2023 is concerned, the auditors had no idea that any additional subscriptions had come in, and they signed off on those accounts. The second set have this added, but I'm going to tell you the only correspondence we've seen about that is an email. I think it starts at 2450, 2451. And basically that trail of correspondence is between Gerhard van Rijn, who is the auditor in Cayman, and Mr. Van Vuren and others within Aria and the fund. And I just want you to look at the email July 29, 2024 with the blue text in it.
Can you bear with me because that's another corrupted document.
Oh, sorry.
No, that's okay. I just need to go to the online version, which is slower.
Sorry, could I have that page number again, please?
It's 2457.
Thank you.
No, sorry, I'm looking for the one.
Well, the online version isn't loading either. I'm going to have to
yes.
reboot the online version. So.
No, 3.
When
there's this blue text, it's above it.
Okay.
Just going to 2458 and note 3. This is Aria saying my understanding is we need to disclose significant subscriptions, redemptions post year end. So we propose to update the disclosure for this. Significant time has lapsed since 2021. Perhaps we just aggregate the total subs and up to the end of signing now and refer to those numbers in the note. Let me know your thoughts. And the Mazars auditors said, I agree. Aggregate the subs and total reds from July 1 to date. So it seems like taking the existing audited accounts, he said if you want to add in, you should disclose further subscriptions and redemptions, and then they've added those in. There's no evidence that any further consideration was given to that or any porting exercise has been reviewed and audited or checked. That's just a note of what's happened since the audit period, and it's coming from Aria. So that's a point on that. But the main point is that there are no accounts for 2022, no accounts for 2023, no accounts for 2024. And we're told that they're in progress and they'll be coming. But the other point is that's all we've seen. We don't have management accounts. They don't appear to have been keeping books of record for this period in question. Certainly we've not seen any. And another point that Kroll have made, that would make it impossible for this kind of operation to be effectively managed, particularly by one person. So Kroll make that observation at page section 8 of their report 4805. Now, all we've got in response to that serious criticism is Mr. Britton is saying that the 2022 and 23 accounts might be completed soon. And they've put in evidence from Mr. Van Buren, who's a director of the fund, and from Campbell's. I'm not going to go through that, but what they say is, well, it's perfectly normal for people not to file accounts in Cayman. And I submit that's an unsatisfactory response to the criticism that's been levelled. It's a legal obligation to file these accounts, but also it's a legal obligation to maintain books and records. And when you're being criticised for not having done so, it's not an effective response to say, well, Campbell say, well, delays are common in Cayman funds. I'm not sure if that's a legal opinion or not, but it shows in my submission a complete disregard of what's been alleged, and a lack of response to the evidence. Then I think some small but important final points. The corporate structure of Aria, in inverted commas, and the Aria group, in inverted commas, has been unclear right from the start of this case. Your Excellency, you observed at the ex-party hearing that Mr. Britton's evidence in Hong Kong used the term Aria interchangeably to mean the fund, Aria Dmcc, and so on. And that's in your reasons at paragraph 38 to 41. I remember from the transcript, I actually remember you saying it fudges things nicely because he just used the word Aria and it wasn't clear to work out whether he was referring to DMCC, the fund, or other entities. We haven't got more clarity on that since. We've got an organogram at page 2586. And that's Mr. Britton's current version, where he's now saying it's not all the same. There's actually 3 different groups within the group. Let's go back up. 2 pages of this, but he's saying that there's a group of companies related to the DMCC company. And you see that tree there. And at the top of that, you've got UBO Matthew Britton, although we know that the shareholder was Mrs. Britton until July of last year. Then he says there's an Aria Cayman group, scrolling over, which is a completely different, unconnected group. And that's got companies like Keirstone, Gloppet, etc., Aria Commodities International. And then there's a 3rd branch on the next tree, which is Aria Capital Management KY Cayman, and Aria Commodity Finance Fund Cayman. So that's the fund. So that in fact shows that there's no obvious connection between the fund, DMCC, or any of the other companies at all. They're not part of the same tree. They're separate companies, separate structures, even on this version of events. So when monies come into Aria DMCC, they're not coming into the fund. And when monies end up in all of these companies on the 2 trees, they're not ending up in the fund at all. And then there's sort of perhaps a smaller point, but this, if you look at the fund tree on the 2nd bit of the page, the fund seems to be owned by what's called Aria Capital Management (location KY, we don't have information about the ownership there. But that management company is referred to in different ways in different places. It seems to be not one management company, but two. There's one in Cayman, there's also one in Dubai. And just to show you that, when you look at the PPMs, they each list that company differently. So just it's a small point, but if one looks at, for example, the 2020 PPM and look at the management company, it's on page 387.
Sorry, can I,
Yes,
before you leave the org chart?
Yes, sorry.
So Aria Capital Management is a separate company from the Aria Cayman Group.
Yes, that's what he says.
Okay.
Yes.
Yes, sorry. Yes, do continue, please. Page 387.
Yes, 387. Then this is the 2020 product placement memorandum for the fund.
Yeah.
And it says investment manager. And then it says the fund has appointed Aria Capital Management FZE as the investment manager of the fund. And it was incorporated in the UAE 2014 with registration number 44320. And then I think further down, you see promoter, Aria Capital Management Limited. And that's, I believe, referred to as the Cayman entity there. And then,
just have a look.
yes, sorry.
2020 PPM investment. Yeah.
But the 2019 one says things slightly differently, and that's at 294. There you see the Cayman Fund as the investment manager.
Who appointed Aria Capital Management
Limited.
So
Yes, and that's it says it was incorporated in the Cayman Islands.
Yes, that's a Cayman.
So even that organogram just seems questionable in many ways. But the main takeaway from it is that Mr. Britton's case is that it's completely separate, the fund, from anything else. So the assets didn't come into the fund and didn't reach the fund if they ended up with those entities. Your Excellency, so next point, just simply the lack of information from the fund administrator. We don't really have anything from them which backs up any of the story that's been told about the monies and the assets. We have a letter from them, not a witness statement, and it simply says 7441, Mr. Diantos. This is all the fund administrator was prepared to say in these proceedings. It basically says the third paragraph, I think, IFS Greece has acted as the administrator. IFS Greece is responsible for the preparation of periodic NAV statements, the maintenance of accurate updating of the fund shareholder register, the processing of subscriptions, and the delivery of reporting. And then it says we've done it under the supervision of the fund, and they don't actually exhibit the full share register. The NAV statements that we're now told to rely on don't come from this fund manager, etc. So that's a startling lack of evidence from the fund manager. And then finally, the trade license of Aria Dmcc. The role made a point in their report that what Aria Dmcc had been doing, namely receiving large amounts of investments, was outside the scope of their trade license because they are supposed to be a commodities company. And then Mr. Britton, we had exhibited the trade license of Aria Dmcc, which gave it permission, the license, to act as a commodity trading company. The idea that they were receiving investments of hundreds of millions of dollars seemed to go beyond the scope of what that kind of company should be doing. Mr. Britton has answered that by saying they have a second license, and I'm going to show you that. He says the second license we have permits us, and in fact he admits, he said, of course, it would be outside the scope of my license if I were just a commodities company, but I've got this other license which allows me to do this kind of thing. And so he exhibits that at page 7137. And that's the DMCC license that he relies on. It's the second license. It's called, at the top left-hand corner, service license.
Sorry, it's another corrupted one.
All the good ones are, it seems, but
Sorry, can I get that page number again? I missed it. My apologies.
7137. Is it corrupt beyond?
I'm just waiting for it to load. I'm just waiting to load online. That's all. Yeah, I have it now.
Right, so it's called a service license, which is on the top left-hand corner. And then if you scroll down, it permits certain kinds of activities. Number one, at the bottom of the page.
Yes.
Investment in enterprises and management. So what Mr. Britton says is, yeah, the first license, which is trading, that would be what we've done, would be outside that license, but we've got this other license, which allows us to invest in companies and management. But my submission is that what he says has actually happened. This goes way beyond what that kind of license does. If it is true that this license allows a company to invest its own monies in other companies, and it allows companies to set up other companies with their own money. What it doesn't possibly allow you to do is receive investments from other investors to the tune of $400 or $500 million and invest on their behalf. For that, you would need to be regulated for financial services activities, just like the Cayman Fund is, just like any investment fund in the DIFC is. And we say onshore is no different. I mean, I can set up a DMCC company. I can trade. I could even invest my own monies in that, but I couldn't act as a lawyer in the DMCC without a license from the Dubai Legal Affairs Department. And likewise, handling public investments or investments from third parties requires a financial services license. This goes way beyond that kind of license. Now, I did put in some extracts to back that up. But if it's going to be controversial, I'll just leave it with the general point that if what Mr. Britton is saying is that he borrowed hundreds of millions of dollars and then invested it on behalf of FDT and us, then he just wouldn't have been licensed to do that in the DMCC. That requires a financial services license.
Well, let's just leave it there for the time being.
Okay. And the very, very final point is again, Paul, Your Excellency, just on the facts. You'll see, or you'll have seen that my learned friend has attacked Kroll, attacked their independence and objectivity and so on. Mr. O'Broyd, who prepared that report, and his team have wanted to just put a letter in by way of response to confirm that they've acted independently and so on. And I don't know if that has made it into your bundle, but I'm going to not really make submissions on it. But I think it's only fair that that letter be read because I think it's only fair that anyone whose professionalism has been attacked like that should be allowed to reply. It's a very short letter with his CV and a declaration that he's acted independently, compiling the report. I'll give you the reference to that, although it may not help because you may not yet have it in your bundle because it only came yesterday. But it's at 3530 in the supplementary bundle.
3530. 3533. 3530.
Yes. I don't know if that has made it to your bundle. But, I'm sorry if it hasn't, but we received it on Monday.
Okay. I'll find it. There's no need to take time now.
So those are my submissions on the facts. I'm going to leave that there and probably spend what time I have left on law and full and frank disclosure. It looks to me, I'm not sure how we are on timings. If we're going to finish at 4, then I'll probably need a little bit of time tomorrow.
I'm happy to sit until 4:30. I don't know what arrangements Mr. Montague Smith has made.
No arrangements, Your Excellency. I'm certainly in your hands.
So you're content if we sit till 4:30 today, tomorrow, and Thursday if necessary?
Certainly.
Yes, I'm obliged. Thank you.
Thank you.
The same goes for me tomorrow and Thursday if is needed.
Okay.
It may be that I'm not going to finish anyway by 4:30, Your Excellency, and I think Mr. Montague-Smith indicated he might need more than a day, but I'll take it off my reply time, whatever time I need to use.
Okay. Well, anyway, let's assume we're sitting until 4:30 today.
So I'm going to talk about the serious issue to be tried test, and I think the first submission is that given what I've just shown you, what we've just gone through, in relation to Aria, the subscriptions, the movement of the monies, the lack of tangible assets, in my submission, there's an unanswerable case here that there is obviously a tribal issue that these monies have been misappropriated. Your Excellency, you framed the fraud case at the beginning of this whole business at the ex-parte hearing in 4 possible ways. And I think I'll take you back to that at the ex-parte transcript at 1200. Paragraph starts moving on.
Forgive me. I thought I was just slightly alarmed before we go anywhere. I have downloaded a supplementary bundle. You say it's at 3530. My supplementary bundle is 3460 pages.
This is the stuff that Mr. Montague-Smith was complaining about.
Oh, okay.
So that is one of those documents, and it hasn't reached your bundle, obviously. We have sent a new link to the updated version, and Your Excellency won't have it now. I don't think I'm going to need to refer to anything else from that. So
let's let that one fall where it lies where it falls at the moment. Okay. Sorry, you want to go to, you said page 1200?
Yes, and you outlined 4 possible ways a fraud claim could be looked at right at the beginning of that ex-parte hearing, and so I mean, right to the end of that page, I can summarize it, but if Your Honour might want to just read that, because
Sure.
I think it stays good.
I may have just been thinking aloud.
Yes, no, I no doubt, but it's really just 2 paragraphs on that page. You get to the first 3, and then there's a bit of then I think the 4th one comes is very short. It's at 1203.
Yes, I'm just.
Yeah, sorry. Please.
Okay.
And then we had a discussion about something else, but we picked it up again at 1203. At the bottom of page 1203, the paragraph that says anyway, you said leaving that aside, there's a fourth possible fraud, which is your case that.
Yes, I've read it.
Yeah, and then you say one is probably not relevant. That's the TrueCoin claim, the TrueCoin story, and so on. 2 to 4 are. Sorry, you say only one is relevant today. I would say that yes, one still remains not relevant for present purposes. We're not here arguing about the wider fraud, but 2 to 4 are, I submit, still relevant. Second, that there was a conspiracy to misappropriate the reserves. We say that involved Aria, Dmcc and Mr. Britton. Thirdly, whether Mr. Britton acted alone or with others diverted funds from the fund to Dmcc. That's the third one. And then the fourth one, that the fund is a fraud. Now, we focused at the ex-parte hearing on the third one. But I would submit that the last three are still very relevant. And today, sitting here today, looking at the evidence that we have before us today, it's much, much clearer that there is an arguable case that the fund is a fraud. That's much clearer at this hearing today than it was at the ex-parte hearing. And I'd submit that if there was uncertainty about that fourth case, that the fund is a fraud, it's Mr. Britton and Aria who have put the evidence in, which can really clearly, you can see that there is a clear argument that the fund was a fraud, as well as the diversion of the monies to the DMCC company. So I'm going to just talk about the legal points now, because I think the facts points do back that claim up. And I also submit that my learned friend and his clients haven't really engaged with those facts at all. What they're relying on are two things: some legal arguments that we didn't have a proprietary interest at all, that we authorised somehow this to happen, or that Mr. Britton didn't know anything about it, and pleading points. And it's those that I'm going to be dealing with now: the legal arguments and the pleading points. So I'll turn, I think the first one really is the proprietary interest, which I think is the meat of it, and it is something that we did discuss quite extensively at the ex-parte hearing. So I'll start with that one. And really, Techteryx's case remains as it was at the ex-parte hearing. That the primary case is that we own those reserves, and that FDT were holding them on trust for us. That's the case I made to you, and that's what I'm going to focus on answering my learned friend's counter arguments today. Thankfully, there aren't any pleading points taken on this issue. I think it's clear that we have pleaded that this is our money. And okay, I think the first place to start is FDT and who they are. And I think I said at the first return date hearing, the clue is in the name. They're called First Digital Trust, and they're a company licensed under the Hong Kong Trustee Ordinance. And my learned friend has exhibited bits of that ordinance, but that ordinance provides licenses for companies to act as trust companies. And that's what FDT were and are. So I'm going to look at the three agreements which we made with FDT. Again, I think we did go over them at the ex-parte hearing, and show you quite clearly that there was a trustee relationship there. So there are three of the agreements. There are the client agreement and the custody services agreement. They were entered into in September 2020. And then there's the escrow services agreement, which followed in January 2021. I'm going to take them in turn, but they form a kind of a hierarchy. You start with the client agreement. The custody services agreement is a little bit more detailed, and the escrow services agreement is even more detailed. So I'll start with the client agreement. I'm going to just show you that on our true construction of those documents is clear FTT, where our trustee expressly under those instruments. So if we can start with the client agreement first. It starts at page 490. And then you can see at page 492, FTT is introduced in section 1 as a company licensed under the Hong Kong Trustee Ordinance. Not too much to take from that beyond what I've just said. But the next clause to look at is clause 2.1, which has a series of definitions and interpretations. And if you skip down that to services, it is at page 493, and it says services means one or more trustee, fiduciary, custody services, or other ad hoc services and facilities made available to the client, that's us, under the service terms, which are these agreements. So trustee, fiduciary, custody, and other ad hoc services. I'm going to just skip through this a little bit quickly if I can, but please slow me down, Your Excellency, if I'm going too fast. The next clause I want to look at is 4.1. Client is acting as principal, and there it says Techteryx, the client, as between itself and a third party may be affecting transactions for and on behalf of another party, but as between client and FTT, the client shall be deemed to be transacting solely as principal. Client acknowledges primarily liable to FTT for all transactions. And submission there is the agreement clearly stipulates rights and obligations between these two parties, and only these two parties, and I'll get more into that. I'll leave the client agreement behind. There's not too much more in that, but the custody services agreement has a little bit more detail, and we find that at page 504. Yes, so just skipping past the introductory bits, I'm looking at clause 2 first. It sort of explains this hierarchy that I mentioned before. So the first line, the custody agreement is subject to the terms and conditions set out in the client agreement. The terms and conditions in this custody services agreement are in addition to those in the client agreement, and the former, i.e. this one, shall prevail for matters specifically dealt with in case of conflict. So that's just showing the hierarchy of the agreements and nothing more I wanted to say about that. The next one, 3.1 is the next one I wanted to look at. Interpretation, again, these are definitions, and if we skip down to property, page 505, it means, as the context requires, all or any part of any securities, digital assets, cash, or any other property delivered to FTT to be held by FTT on client's behalf. The Next, 5.3. Warranties given by the client, that's us. And number 2 there, the client warrants that it has good title to the property and authority to deliver the property to FTT. A warranty of title to the property, and the property including cash, securities, assets, or anything delivered up to FTT. The next one I wanted to look at quickly was 10.
Give me. Property includes cash.
Yes.
Okay.
The next one I wanted to look at is clause 10.1 on page 511.
You're skipping over 6, are you?
6, I'm going to come back to that, but in a different way, if that's all right. And that's not the 6 that you think it is. I think that I will be coming back to 6 because it's all about segregation. But the 6 that I think is on your honour's mind is the escrow services agreement.
No, I'm thinking about this 6 too. Thank you.
I won't try and read your mind, and I'm so sorry. I will come back to 6.2 because I'm just.
So we go to 10.
10.1, yes.
Which is on page.
That's 511.
511. Yep.
Custodial duties requiring instructions. And these are things that FTT may only do upon receipt of instructions. And that includes making payment for or receiving any property, delivering or disposing any property, unless this agreement provides authority to do so. So the property, they're not allowed to deal with it on their own. They have to deal with it on instructions from us. And then the final one in this introductory sort of run through, clause 14. That's, sorry, at page 515. That's fine. So that says not agent for clients, customers, clients, direct liability. And again, if I can just go to the second sentence. Notwithstanding any requirement that accounts documentation or transactions be effected in the name of any customer of the client or any other beneficial owner acting directly or indirectly through the client agrees that it shall be responsible for all its obligations to FTT with regard to such beneficial owner accounts, agreements, and transactions. The client agrees that its customers do not have direct rights against FTT, and FTT shall have no liability to the client's underlying customers. So FTT, the customers are not, FTT are not liable to the customers. I'll come back to this agreement on the point that you were thinking of. I'm just going to look at the ESA, the escrow services agreement now, because I think that's probably the one that has the most discussion that we had the ex parte here, but I am going to come back to clause 6, I promise. So the escrow services agreement at 529. And again, clause 1 first, just to sort of repeat that point about the hierarchy. It has similar language to the custody services agreement, and it says that both of those other agreements, the client and the custody service prevail, and the escrow services agreement is subject to those terms and conditions, but then it says the terms and conditions in this agreement are in addition to those in the others, and the former, as in this one, shall prevail for matters not dealt with in the others. I think that's also set out in the Learner Friend Skeleton. I think that's uncontroversial. Now, to the meat of this, recital 1 at the top of the page is where we find the word trustee, and there's been a bit of heat about that. But it does clearly say, whereas the client and FTT entered into a client agreement and custody agreement on the 28th of September, whereby FTT agreed to provide trustee, fiduciary, custody, and other related services to the client, subject to the terms thereon, and so on. That can't be clearer in my submission. It does say that they have agreed to provide trustee services, and it refers to both the client agreement and the custody services agreement. And by entering into those, it says that FTT have agreed to provide trustee, fiduciary, and other services. That FTT are party to this agreement, and this records their agreement to act as trustee in relation to this property. And I don't see how there could be much dispute about that. But I know there will be, but I'm just flagging it. Next, recital 3. And there we see the client will be offering tokens reflected on a blockchain, and the language is in exchange for US dollars or fiat currencies deemed acceptable to the client from time to time into an escrow account with FTT. So it's clear that FTT and Techteryx recording in their agreement, the point of it is Techteryx are going to be offering tokens in exchange for cash, and that cash is going to be held in an escrow account by FTT. And then recital 4, going on from that, the tokens are to be redeemable from the escrow account. But remember, clause 14 of the previous agreement, customers don't have any direct claim against FTT. They only have, they don't have a claim against FTT. And then recital 5, it says, well, because of all that, Techteryx want to set up an escrow account, and FTT agree or desire, to provide such an escrow account in accordance with the terms and conditions below. And then that is recorded again in section 2. Establishment of an escrow account. FTT shall establish an account for the funds received from the purchasers. And then for the purposes of protection communication, FTT will administer the escrow account, but may rely on communications received from the holders via software created, maintained, and managed by the client. Then 2 more clauses, and I'll ask if you want to take a break at that point, Your Honour. But clause 3A, further down the page, there are 2 parts to it. Sorry, no, there are 3, but I want to talk about 2. The first one is that during the escrow period, number one, FTT will act as an agent of the client for receipt of the funds from the purchaser. So it's acting as agent, taking the money into the account. And then two, upon receipt of the funds, FTT will hold the funds as a fiduciary of the client to the order of the client, subject to section 4F. And then three, sorry, I should also mention, FTT will redeem the tokens upon the instruction of the client. So again, it's not the token holders or the customers who deal with FTT. It's Techteryx who authorised the redemptions. That's what's agreed. Now, it does say subject to 4F, and Your Honour, you did refer me down to that. Let's go to 4F. Sorry, I'll just go to 4 first before we go to 4F. So 4 talks about how the deposits are made into the escrow account and taken out. But 4F is the one that is important. It is a caveat to what we just looked at. So if we can just flick down to that. So this is an exceptional scenario where, contrary to the general arrangements that we've just looked at, the holders have direct rights to redeem with FTT. But it's an exceptional clause, and it only applies when there has been a triggering event. And if you go down, you see what those are. Disability, breach of obligations, intervention, unlawfulness, etc. So when those exceptional events happen, Techteryx cannot redeem, then FTT customers can redeem against FTT. And for that purpose, if you scroll further down, it says that on those triggering events, FTT have to segregate the monies and hold them as resulting trustee on behalf of the holders rather than on behalf of Techteryx. I'm going to perhaps take a pause there, Your Honour, if that's convenient. If you are taking a break, I thought it's just the halfway mark, but I'm quite happy to go on.
Bear with me 1 second. Yeah, I actually thought you might just go on a little further.
Yes, I shall.
If you've got another 15 minutes or so, then take it.
Okay. So then clause 6 of this agreement is something we did talk about at length because there are 2 parts to it. The first part, FTT shall hold and manage the escrow as fiduciary for the benefit of the client or its agents or designees. But then this sentence, for the avoidance of doubt, the client shall have no proprietary rights in the escrow amount and shall hold for the benefit of the holders. And then it repeats, notwithstanding that, FTT shall not be required to engage with the holders directly, and all redemption requests to be made to Techteryx, further communicated to FTT by Techteryx, and so on. So there was this tension between that second sentence and the other references in the agreement to holding on our account as fiduciary, trustee, etc. And Your Honour, we went through that, and I think your observation was just because FDT are holding on our account doesn't mean that it's also the holders may have also got rights. There may be a sub-trust here, and that's why the argument is pleaded in the alternative in Hong Kong. It's to take care of that ambiguity between that second part of clause 6 and the other parts.
Yes, the intention appears to be that FDT will be an agent for Techteryx, but as a fiduciary agent.
Well, it certainly is supposed to be a fiduciary, and it does manage the monies on our account. It does also agree that it's acting as trustee, or providing trustee services. The question is there any contradiction between, for example, acting as a trustee for us, or recognising that there may be a sub-trust with the holders also having beneficial rights in the fund? I think that it's obviously trying to take care of the position of the holders, but the clauses don't all match together. But we would say,
so you say this means that it recognises that Techteryx is that the client shall have no proprietary interest and shall hold the escrow account exclusively for the benefit of the holder. So I'm just trying to work out who's meant to be holding what. For the avoidance of that, the client shall have no proprietary interest in the escrow account and shall hold the escrow amount. Oh, not account, amount. No, they're both amount.
yes, they are.
Sorry, shall have no proprietary interest in the escrow amount and shall hold the escrow amount exclusive. So FDT is saying, so you say that FDT is saying that Techteryx is a trustee for the benefit of the holders.
Well, I think what we're saying
of the escrow amount.
What we're saying is we are the owners of these funds, and they are holding it on trust for us. We are saying that under the way that the tokens are bought, the holders only have a contractual claim against us. So that's our primary case.
As between you and the holders. But what appears to have been in the contemplation of FDT, rightly or wrongly, and I don't know whether they had sight of the documents between you and the holders, appears to be saying, doesn't it, that they regard you as trustee for the benefit of the holders.
That's an alternative way of looking at it. I mean, what we say is the reality is the holders didn't have beneficial ownership of the monies, but they did have residual rights to claim against us. But if our primary case is wrong, then there is a sub-trust relationship with the holders, but that doesn't affect the fact that FDT are holding the funds on our account and for us. And that's
the next step, isn't it? Because if FDT think that you're a trustee for the benefit of a third party of a fund, what is the capacity in which they hold that fund?
Well, they're holding it. We say as trustee or fiduciary. It doesn't really matter, I will say. But when you look at these agreements in the round, there is a confirmation that what we give them is our property. And that property includes cash, that the end token holders don't have any rights against FDT. When you look at all of that together, our primary analysis is they were a trustee for us. If that doesn't work, and we are also a trustee for the holders, it doesn't really make any difference because we can still claim against FDT under that arrangement. And I think the plain fact is that part of the agreement doesn't add up with the other clauses that you've mentioned. It's not a perfect agreement, but I don't think it undermines what you can see clearly, which is FDT are holding the funds for us. The holders don't have any rights against them, and they have to do with those funds what we tell them, and they're setting up the account for us to hold the monies.
But if they believe that the beneficial title rests with the holders, then they can only hold a bare legal title.
Well, ultimately, they don't have. They can't hold anything else. I mean, they've never. They have made it clear that they're not holding these funds as their own. So the question is.
Well, forgive me. That's not the case that is put against you. The case is put against you is they invested their own money.
FDT.
That's what. Yes, I mean that's what Mr. Britton says, that he received an assurance that there was no interest in the money.
We'll come back to that. That's plainly not right from these agreements. FDT are agreeing not to say thank you for the money. It's ours now. I mean that doesn't make any sense at all.
But just on analysis, and from this document, and I'm sorry I did say I wouldn't interrupt you, but this is rather important.
It is.
If FDT contemplated that the holders were the holders of the beneficial title to the escrow amount, then they accept that they would only be holding legal title, bare legal title.
Yes. I think so.
Well, how would they hold bare legal title other than as the trustee?
Well, I just don't see how they can say that they have beneficial title based on any of these documents at all.
Anyway, that's something that just occurred to me and needs some thinking about.
There's no question that clause doesn't fit with the other ones that I've just gone through, and I think I can leave it there. But whether it is on trust for us or on trust for us with ultimate beneficial ownership of the holders, it in my submission doesn't matter in terms of their obligation to account for. Well,
I suspect we're going to come back to this, both in Mr. Montague-Smith's submissions and your reply. But shall we take the break there? I just wanted, as I said, to think out loud about 6. Good. Okay. Let's come back at 20 to the hour, which is 20 to 1 London and 20 to 4 Dubai. Mr. Montague-Smith, if at some point you need longer than these breaks because of the time difference, do let me know.
Oh, that's very kind. No, thank you. The one thing that is going to cause me slight difficulty is that we've just discovered that since at least Council downloaded the supplementary bundle, it was amended by insertion of the entirety of the trust ordinance from Hong Kong, which added 600 pages and puts all of my pagination in my notes out of sync. So my friend might just bear that in mind as he goes through. I think this is symptomatic of something that's been going on all along, which is a liberal approach to updating bundles without telling us at all.
Yes, well, I'm rather opposed to updating bundles which changes the pagination. It makes life rather difficult for me as well. Okay.
sorry, look into
Yes.
that. It wasn't intended to put the full trustee ordinance in it. It was a mistake. We'll try and see if that happened.
Well, if you can sort things out, you may have to do it overnight. So Mr. Montague-Smith's notes then back to where they should be.
Sorry, if I may just suggest, I mean, it sounds like from the pagination that your lordship gave, that you've got the one that includes the full version of the ordinance. I don't. So it looks like it's my notes that are out of sync. So I'll do the exercise of updating my notes. Let's stick with the version that's been downloaded from the website.
Well, I can tell you, yes, I've downloaded. The version I'm using is V2.
Right. Yeah. So I think what happened is we downloaded V1 and subsequently I certainly wasn't able to access the online bundle. I was given a link, but it never allowed. It constantly said timed out. And now I've just literally just now found that there are another 600 pages. So it's a slight. It's for your purposes, my lord. It's just a moan. But for my learned friend's purposes, what it means is, if he could just take his time when he's going to paginations, because I will need to use the duplicate bundle and compare it to my notes on the other one. But there we are.
Yeah. Okay.
It is what it is.
It is what it is, and bundles are always a problem. There you go.
Yeah.
Okay, well let's take a 10-minute timeout.
Thank you.
I'll see you both back at 20 of the hour.
Very good, thanks.
A bit early, might as well proceed.
Sorry again. Oh, not hearing you, Your Excellency. Sorry.
I'm so sorry. I forgot to unmute my mic. I said we're a bit early, but we might well proceed. But now, of course, it is exactly bang on. So.
So the next thing I want to talk about is segregation, and my learned friend raises that in his skeleton, paragraph 83. He notes the clause 4F that we looked at, which said that, you know, on a triggering event, assets had to be segregated and held on resulting trust for the owners. And then he also refers to clause 6 of the custody service agreement, which is the one that Your Excellency was looking at earlier. Can I just turn back to that then? Paragraph 6.2 at page 507. And the simple point I make is that quite clearly 6.2 is headed segregation of assets. And the main part of the clause says that property has to be held in a manner that it should not become available to the insolvent administrators of FDT, meaning that it has to be segregated as not FDT's property. Then also 6.2.1, the property needs to be identified on its records in a manner so that it is readily apparent that the property, one, belonged to the client or its customers, and two, not belonging to FDT, and three, segregated from FDT's other assets. So
yes, I wondered how this squared with the idea that the relationship between FDT and Techteryx was one of debt and credit.
But it doesn't. That's quite clearly right. It isn't that sort of relationship at all. It's a trustee relationship, we say. 6.1 says the records that identify custody accounts in the name of the client to show that the property belongs to the client and is segregated from FDT's own assets and those of its other clients. So that's that. And then going back to the escrow services agreement
well, sorry, let me just, I think 6.3 is also some important. So we have a look. The FDT will hold So the question is, FTT shall identify property on its records, so it's readily apparent the property belongs to its customers. But then it says custody of cash. FTT will hold clients' cash deposits in one or more omnibus bank accounts, a fully segregated bank account established principally for the client, and or one or more omnibus segregated market accounts. Each client money bank account is to be named FTT, in the case of segregated account, joint names, separated from FTT's business, established. Blah, 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 blah. A client agrees and acknowledges that the client's money bank accounts do not create or represent any relationship between the client and any of the banks. And then 632, cash deposits are held across client bank accounts, proportion of all clients' cash held in omnibus accounts, except in the case of segregated account, not treated as FTT's general assets, fully owned by the client.
Yes.
So again, so specifically in relation to cash, the client's cash deposits are fully owned by the client.
Yes, that's correct. And then it's clear it can't possibly be said that FTT thought this was their money, nor that this is a debtor-creditor relationship. The provisions make it clear that the assets are not FTT's, cannot be treated on the FTT's insolvency as part of FTT's estate, etc. That's what happened. They were paid into custody accounts. And also, can I just go back to the escrow agreement, because that's even clearer.
Yeah.
Page 530. It's clause 2, which I pointed to not long ago. FTT shall establish an account for the funds. So it's a separate account, and then it's segregated in that way. And just to show you that that did happen, you can see, for example, some of the subscription documents, 4078. There's a whole list of these, but if you look at custody account 100424, I'll come to this maybe later, but there are many examples of that account labeled TrueCoin. That's a separate account for TrueCoin monies. I haven't got the ready reference to hand, but even Mr. Britton's documents show separate accounts for these payments, custody accounts. They're not FTT's own monies. 617, I'm told, shows you. Oh no, sorry, I'll not go to that. Yeah.
No, I have seen those documents headed TrueCoin.
Yes.
And it's referred to in your skeleton, I know.
Yes. And then I think just the final point on that, FTT were actually obliged to segregate the monies under the Hong Kong Trustee Ordinance. I haven't put the full ordinance in, and neither has my learned friend. He's put one section in. In the latest version of the bundle, when you get it, you will find section 89 of the Trustee Ordinance. I'll tentatively give you that page reference, but I don't expect you to have it. 3631. What that says is you don't have it, do you, Your Excellency?
No, I go up to 3460.
You will get it, and it's one provision.
Well, actually, I can probably get it online.
Yes,
it's on file. If you bear with me a second. Supplementary bundle timed out. Log back in. Give me the page number. 3631.
3631, yes.
Yeah.
So yes, trust funds to be kept separate.
But
All monies, property and securities received by or held by any trust company, which FTT undoubtedly is, in a fiduciary capacity, which we say it undoubtedly is, shall always be kept distinct from those of the company and in separate accounts marked in the books of the company, distinguished from any other, etc. It's the same as what the contracts say. If they had to segregate it, and they agreed to segregate it, and they did segregate it.
yeah, so to look at all monies, property, securities received or held by any trust company in a fiduciary capacity, should always be kept distinct from those of the company in separate accounts, as so marked in the books of the company. For each particular trust has always to be distinguished from any other in the registers of books of the account, so that at no time shall trust monies form part of the trust to which the investments belong. And it seems to contemplate, well, this is about trust funds, but maybe it's argued that these weren't trust funds.
Yes, well, a trust company holding funds in a fiduciary capacity needs to segregate them, is what it says.
If they're trust funds, but if it's said that the contractual relationship is one of debtor and creditor, then it may be that this clause does not apply. Anyway, I'm breaking my own word and interrupting, but anyway.
No. So that's that. I mean, my submission is they agreed to segregate them. They did segregate them. They were obliged to segregate them by law, and it's not a debtor-creditor relationship. The sub-trust argument is an alternative to the primary argument that these are our monies and they hold them on trust. If ultimately we are holding them on trust for the ultimate for the token holders, then it doesn't make any difference in my submission. And we did raise that at the first hearing. It's not correct to say that it wasn't advanced at the first hearing. It's pleaded as an alternative variant of the claim. It wasn't discussed extensively at the ex parte hearing, but Your Excellency raised the point at the beginning of the hearing and made the point that it's not inconsistent with a proprietary claim against FTT by Techteryx if the coin holders ultimately had beneficial interest in it. So that's an alternative argument. It's not controversial that sub-trusts can exist. That's I think accepted in my learned friend's skill as an argument. So I don't think I'm going to delve into it much deeper than that, because regardless, we say we have an interest and a proprietary claim, whether it's our monies or whether we're holding on behalf of the token holders. So I'm not going to look at that. I'm going to look at quid close trusts because my learned friend raises that in a skeleton argument, and he says, I think he said, well, the funds may not have been segregated, and unless they were segregated, a quid close trust could not arise. Well, I think this is only relevant if you think that there is not enough express language in those agreements to hold that we are a trustee. An alternative argument is that was the intention, and that is the test for quid close trust. And I'm referring to the case that my learned friend has cited there. He cites Bieber and Tethers, and I'll just flag that up. It's at 2470. Yes, really paragraph 15 I want to look at. So there's 16.
Bear with me a second.
The question in every case. Yes.
So what page? 2470.
2470, yes.
Doesn't look like a law report, but it's corrupted. No, well, it's not a law report. Oh, it's 2470 in the supplementary bundle.
Oh, I'm so sorry. Yes.
Yeah. Okay. Yeah.
I've tried to flag all of these.
Yes, I've got. Yes, do tell. Yes, make sure you know which bundle it is.
So the question in every case is whether the payer and recipient intended that the money passing between them was to be at the disposal of the recipient.
Sorry, where are you looking?
Paragraph 16.
16. Yeah. Okay.
And then paragraph 18. It says, thirdly, it must be clear from the terms of the transaction, properly construed or objectively ascertained that the mutual intention, the funds transferred should not be part of the general assets of the recipient, but used exclusively to effect particular identified payments, so that if the money cannot be used, to be returned to the payer. The mechanism is a trust giving rise to fiduciary obligations. And then I think that perhaps the most important bit I take from this is paragraph 21. It's the subjective intentions of payer and recipient as to the creation of a trust are irrelevant. So whether FDT and Techteryx intended there to be a trust or not, if there's a difficulty in construing that, that's not the point. It's the overall purpose, and segregation is an important part of that. So that's another way of looking at it in my submission. And then I'll get to constructive trusts here next. No, I think there's not actually too much between us on this, but my learned friend takes two legal points, I think. He agrees that constructive trusts can arise in cases of fraudulent taking of property, and he refers, as we do, to Westdeutsche Landesbank, Giro Centrale and Islington LBC. That pithy judgment of Lord Brian Wilkinson, constructive trusts arising in cases of fraud. And we look at that, it's page 3177, we've both cited it. And it is the stolen bag of coins. Stolen bag of coins down at H, and that first paragraph there. So cases of fraud, talking about a thief who steals a bag of coins. At law, those coins remain traceable only as long as they're kept separate. And then a couple of sentences further down. Monies can only be traced in equity. There's been some stage of breach of fiduciary duty either before the theft, there was an equitable interest, or it arises on resulting trust after, and then he agrees that that's right, but says it's a constructive rather than a resulting trust, and concludes at the end, money stolen from a bank account can be traced in equity. My learned friend says that that passage has been doubted, that sort of analogy, and I think the point that gives rise to the doubts is that whether a thief can pass property or can be said to hold property on trust for the owner, because a thief obviously doesn't take title when it steals things. But really, the point is that the constructive trust arises to protect the original owner of the monies. So we're not dealing with a stolen bag of coins or a stolen bicycle here. We're dealing with a fraud case in where money was given by FDT to Aria Dmcc, and the doubts of that statement, I say that there are also doubts about the doubts, if you like. They've got, we've got a judgment from Mr. Justice Etherton, National Crime Agency, and Rob. I just wanted to answer that point that Lord Brown Wilkinson's dicta that a constructive trust can arise in cases of fraudulent taking. So that's doubtful, but it's actually, the doubts have been doubted as well, and that's a House of Lords authority. Now, I've tried to put that in, but I don't know if it's got to you yet. Has it?
So put what in? National
Crime Agency and Rob. Yes. Okay. It has, I believe, 3584. A supplementary bundle. 3584 of the online.
Yes, I'm going to go online. 35.
The online bundle.
Okay.
Yes, we're looking for paragraph 40.
Bear with me.
Yes, I'm sorry.
Okay, I have the first page.
No, I just want to skip ahead to 3595 at paragraph 42. So
Okay.
So yeah, just simply, Mr. Chair, Etherton there said that that's not really a conceptual difficulty. Scholars have found it to be so, but in the normal case of fraud where money has gone from the victim to the actual fraudster, there's no real answer to that, to the idea that a constructive trust can arise. This isn't a bicycle that's been stolen and gone somewhere else where you can say it's always the owner's bicycle. Now, just saying that that passage of Lord Brown-Wilkinson is not uncontroversial, that fraud can give rise to a constructive trust claim for fraudulent taking in circumstances where things have been effectively stolen. And then, so that Muller and Friends' answer to that is simply that dicta has been criticised. It doesn't mean it's not good law, and it doesn't mean actually that the claim cannot arise if, as we say, this is a situation akin to fraudulent taking. So that's objection number one on the constructive trust. That's our response. The second objection is he says that if it's not simply a case of fraudulent taking, if it's a misrep claim, that you're claiming that a contract was entered into by reason of misrepresentations, then you can't have a constructive trust until you rescind that contract. And he relies on the Shalson case there, but sorry, in fact, the Shalson case, which he has cited, clarifies that that's not a strict requirement. So if we look at that, it's page, the supplementary bundle 2694. And I'm looking at paragraph 127. Oh, is that right? Yes. So basically, you don't formally have to rescind the contract. Claiming your money back, it can be amount to that to give rise to the trust.
I'm sorry, I've lost the page reference. You'll remember my references are out by 600 odd pages.
The supplementary bundle reference is 2694.
Thank you.
And then
so I'm just waiting for it to load.
Yeah, excuse me.
Right, 2694 page, power
127.
Yeah.
And then I think the final case I would like to rely on.
Where does it say about claiming your money back?
Sorry, it's the issuing the claim, the Part 20 claim.
Yes,
is treated
as upon implied rescission. Okay, so issuing the claim was implied rescission.
And then one more authority on this, if I may. It's Halley and Law Society Court of Appeal decision 558, the supplementary bundle 3558.
Supplementary bundle, yeah.
3558.
3558.
This is a case of a fraudulent investment scheme and monies ending up in the client account of a solicitor who was intervened by the Law Society, and then there was a dispute about who owned the money. If I can, I'll just skip to the appeal on the rescission issue, because yeah, it was said by.
So where we go?
I'm going to paragraph 34 and just giving some background before I do. 3566. 7, sorry, 6 and 7 over the page. So what was being argued in that case was that the person who'd invested the money couldn't claim it back because he hadn't rescinded the contract with the investment scheme and so on. Just the point that one of their friends making. And then from paragraph 40 onwards.
Having certified really gave notice to upholders which mortgage.
And if
until the decision. Okay, so 334.1.
yes.
Yeah.
And then, I mean, I could invite you to read paragraphs 40 onwards, but the conclusion is 48. And this is Lord Justice Cornwall.
3570.
3570, excuse me, I've not. Yes, 47 and 48, if you can, sorry, just turn up. 48 really was the conclusion. That is citing Lord Brian Wilkinson's fraud test and then saying that the rescission isn't a requirement in situations where you've got a pile of worthless documents, which we would say is very similar to the situation that Techteryx found itself in. Then I think the last sub-argument here is trustee or fiduciary. And my learned friend says, well, we're just a fiduciary rather than a trustee. And we say it rather like that quist close case, it doesn't actually matter if this is a formally constituted trust or if they are fiduciaries looking after property on our behalf. And I'll take it just to a couple of authorities on that quickly. First one is Lewin, paragraph 4411 at page 1307 of the supplementary bundle. And that's an introductory paragraph talking about the trust. And it says it's not confined to trust in the strict sense, but also property subject to a fiduciary relationship. And then distinguishing between a situation where an agent has a personal liability to account to his principal and other fiduciary obligations.
Sorry, where are you looking at? I've got it.
So that they call those kinds of fiduciaries quasi-trustees, and they say that the rules apply to them just as much as to strict trustees.
Okay.
Then another authority on that is Agib, Africa and Jackson. That's at page 95 of the supplementary bundle, but I'm going to refer you to a passage on page 120, if I may. And just at the top of that page, between A and B, the only restriction is that there must be a fiduciary relationship which requires the assistance, or which permits the assistance of equity to be invoked. And just...
Sorry, forgive me.
No, forgive me, I'm sorry, there's later in that paragraph.
No, I mistyped. So I'm sorry, page 120.
Sorry, it's page 120.
I have it then.
Yeah. And I think it's there that it says the requirement is readily satisfied in most cases of commercial fraud, since the embezzlement of a company's funds almost inevitably involves a breach of duty. Now that, I guess, is talking about companies' employees or agents, but I would say it applies more widely. Just two more very brief references. We've cited a Hong Kong Court of a Final Appeal decision on the same point, which I'm also hoping I can find in my bundle 3530 3538.
Go back on the internet.
3538. It begins. I think.
Yes, I have it.
And that is a Court of Final Appeal judgment with Lord Hoffman delivering it. I'm going to look at paragraph 20, and it makes the same point, more or less, that I've just made. But obviously, it's Hong Kong law.
Let me just scroll down to paragraph 20.
21.
21.
So I do apologise, I've got that wrong.
Scroll down to right. That's
3548.
Yes.
So we say that terminological confusion, judges using the term constructive trustee, but simply skipping to the end where he refers to Millett, Lord Justice Millett devised a useful clarification of calling such fiduciaries Category 1 trustees whose trusteeship arose from a wrongful act like the purchase of an undervalue. And then 23. The sort of second half of the paragraph. But all persons who enter into fiduciary relationships are Category 1 trustees. The category is not confined to those who agree in respect of the property in question. All such fiduciaries must be deemed for limited purposes to acted in accordance with their duties in the same way as consensual trustees. Anyway, that's simply taking the point a little bit further. And then the final reference on that is the case that Your Excellency flagged at the first return date hearing, the Rukadze decision. I know that you've read it, so I'm not going to. Can I just give you the paragraph?
I don't pretend to understand it, particularly the passage you cited. It seems to be there may be a typo in it. Let's have a look.
Well, I wanted to just look at Lord Leggett's judgment and Starting at paragraph 90.
Reference.
That I somehow have lost, excuse me. 535, I think, of the supplementary bundle, yeah. Yes. There is some background there, but I want to look at misuse of trust property, paragraph 95. And it says the fiduciary duty, which references to the profit rule, obscures the duty of trustee.
Yes, is it? Well, it says obscure is, so there's a typo.
Have I mistyped that in my?
No, there's a typo in the law report. I thought that's why. The fiduciary duty, which references to the profit rule, obscure is the duty of a trustee. So
yes.
I thought it was something which is so clever I didn't understand it, but it's a simple typo. So much the better.
Oh, good. So it's the duty of a trustee, and then going to the next part, not to use property or the opportunity of the principal for the fiduciary's own benefit, or indeed for any purpose outside the scope of the fiduciary's authority, unless the principal has given its informed consent. And then the next bit I'd want you to look at is the constructive trust device, which is at page 571.
Sorry, let me just catch up.
Yes, I'm sorry.
536. Obscures the duty. Yes, the next reference.
It was 571, and just this passage, but I'm really getting to 233.
571.
Paragraph 233. The constructive trust in play is not for when a benefit is received for breach of fiduciary duty, is not a trust created by the active settlor. And then to the end of that, for example, no one is suggesting that the defendants agreed to act as trustees of holding benefits. Nothing could be more contrary to their intentions, but equity adopts the fiction of treating them as if they had agreed to do so. And then paragraph 234, and just the end of that paragraph, when they're quoting from Lord Briggs in Hui Ching Pung and Hui Kao Mo, which we just looked at. The last part of that paragraph, the court could then order the defendant or anyone claiming under him, other than a purchaser for value in good faith without notice, to transfer him the legal title. It was in essence a proprietary claim analogous to common law action to recover payment. And then on the conclusions of Lord Legate 238, number 1, he talks about the fiduciary duty not to use any property for the fiduciary's own benefit, and then I want to emphasize, or for any purpose outside the scope of the fiduciary's authority. And finally, number 9 on those points. The proper analysis is simply that such misuse is a breach of fiduciary duty which renders the fiduciary liable to be ordered by the court to remedy the wrong by paying compensation or paying over the profits or treating an asset as if it were held on trust for the principal. So that's the remedy for breach of fiduciary duty, the proprietary remedy. And my submission is it doesn't matter whether you classify this as a direct claim as a trustee, under a sub-trust analysis, under a quis trust, under a Westdeutsche fraud trust, or whether you classify it as breach of a remedy for breach of fiduciary duty, constructive trust. The remedy is the same. It's a proprietary remedy. And in terms of whether this is arguable, I would say it's not arguable just once. It's arguable 7 or 8 different ways around. If Your Excellency's got any doubts as to if the construction of these agreements, all of them, is in any way arguable or in any way suggests that FDT are not a trustee, that is a matter for trial. It may be arguable, but it's certainly not the case that what we say is unarguable or not capable of serious argument. And then just to conclude on this, my learned friend's analysis of this is that FDT own this money legally and beneficially. And he says that in paragraph 95 of his skeleton. I say that's completely contrary to the FDT agreements, and it's contrary to all common sense. That can't be the answer to this question. And that is the submission on the proprietary claim. Now, it's 25 past.
Yes,
four.
Long day.
It has been. Everything else.
Let me just catch up on my note. Important. Okay, so that's a convenient place for you to stop, isn't it?
It is. If I could just explain, I have just a couple more points on some of these claims points. I've got a full and frank disclosure to deal with, and I've
yes, you have
the Hong Kong enforceability. So I'm going to probably need an hour at least to finish, and I'll try to compress that as much as I can overnight.
Okay. Well, we have the ability to finesse things with closings and so on. And we're going to sit a little longer than anticipated, so that's fine. Good. Well, in which case we'll start again tomorrow at 10 a.m. Dubai time, another early start for those in London, I'm afraid. Okay, thank you very much indeed, and I'll see you tomorrow. Good night.
Thank you.